From item number 1 to second numbers 3 to 9.
Yes. Why? This is coming up for an application. All right. There is council, non-council, Mr. So-and-so urges that they are lead council, Mr. D. Saraf, representing the respondent number 3, is facing some personal difficulty and is not available today. A request is made to adjourn the matter. The other side, you are here. You have an objection. All right, then. Then we'll not adjourn, sir. We'll pass it or call the council tomorrow. All right. As prayed by learned council, Mr. So proxy council appearing for Mr. Saraf, list on 5th. 5th is a holiday. Let it come up on 8th May then. 8th May, not tomorrow. Okay. 3. Yes. What do you say, sir? When Council Mr. Mehdi, representing the Upland Union of India, submits that he needs to, in view of subsequent developments regarding the annexure file with the affidavit dated so and so, he needs to file a fresh affidavit. He prays for and is granted 2 weeks time for doing the needful. 4 weeks. All right. Yes. A request is made to adjourn the matters on behalf of Respondents Council, Mr. J. Roy. His name is also not displayed in the call list. Press to do the needful and re-notify the matters after 2 weeks.
Numbers 10 to 20.
You are Mr. M. Datta, representing the writ appellant, submits that he needs to bring certain facts which have come into existence subsequently on record through an additional affidavit list after 2 weeks. Yes. Yes. And counsel for the appellant prays for time list after 2 weeks. Four 014. Yes. Oh, okay. And counsel Mr. M. Islam, representing the respondent, submit that he has received copy of the writ appeal recently herein before and needs short opportunity to complete his instructions list after 1 week. Yes. There is no prayer for adjournment. There are fresh matters. It is stated that the arguing counsel, Mr. Datta, is not available today. A request is made to adjourn the matter list after 2 weeks.
Numbers 21 to 20.
Yes.
The numbers 33 to 40.
Mr. Das was missing in action for some days. Okay. Which, yes. Mm. For, on behalf of? You are for the appellant. Okay. Mhm. Right. Mm. Okay. Right. Seems that the tea is still in the process of being brewed. Okay. We'll let you know that today we would not have been able to accommodate you for the reason that the matters from 36 onwards, we are in the midst of hearing. Those are criminal matters. Otherwise, also, we would probably have, we would have sought adjournment. We would have sought adjournment. Okay. So when do you want, please? As you say, it's uh, every date during the course of the week, working days is possible. Don't worry about it. We are here as jointly prayed. Sir, rest assured, if the matter is listed at the same position or a similar position, it will be called out and it will be taken up. That's what we can tell you. So 36 matters, we don't plan to carry them on till June. Don't worry. Yes. List on 13 June as joint for hearing as jointly prayed. Both. What are the interlocutory applications pending still, even though the matters are for hearing? There are two interlocutory applications in both the appeals, 1972 and 1971. What are those? Can we know? They are filed. Let's at least, if they are still pending, if they had been disposed of, they won't be displayed in the call list. You are pleading ignorance just as if it is a bliss, really. आइए क्या है बताइए ना. Where is the आइए? This is the आइए. Oh my goodness. Oh. On the last date, Mr. Kaushik appeared saying that he would be representing. So it seems that there is. Okay. We will like to be enlightened when the matter is taken up. Genuinely. Stay the operation of the order. So the order has not been stayed till date. We can dispose of the IAs, we suppose. What's the point keeping them pending? Yes, this is the application file. These the instant interlocutory applications. Records will remain here. Don't worry. The instant interlocutory application has been filed. Came to be filed along with the appeal way back in the year 2016 with a prayer for issuing a stay on the impugn order dated 28 July 2015. It is manifest that till date, it is manifested from the proceedings that till date no order has been passed on the said interlocutory application, said prayer for interim relief Thus, comma, for all practical purposes, comma, the prayer for interim relief has been rendered odious. The interlocutory application is thus disposed of. However, the record shall be retained as the same will be required in the main appeal. Same order in the other appeal. Yeah. List the appeals for hearing on 13 June as prayed. Same ही होगा वो भी दूसरी application. This is the application. Then just let us see. Where is the second application? Must be the same sister. Stay the operation. Okay, same at the two. 35, yes. Infectious as stated by counsel Mr. N.N. Datta representing the petitioner, comma, the instant writ petition is disposed of as having rendered infructuous by subsequent events. Mark the attendance for the other side. Yes. Mhm. Mm. Why not on 8th? 8th. Okay. मुकुट वो नारायण को बुलाना है, चेयर पुश करना थोड़ा सा. Yes. 49, 50, 51. Yes, what do you want, sir? Miss, you are for the, what's your good name, sir? Mr. A.K. Sahiwala representing the appellant in all three appeals. Praise for time. The other side has no objection. List for hearing after 4 weeks. Not 11th. Not 11th. Chair push karna. Yes. Yes, please. What is the matter about, sir? Plastic waste management. All right. Get it listed on Monday. Very well. Rupam, check it. The rest will do the needful. Don't worry. Okay. Give the slip to the court master. He will get it. Yes. You want it to be taken up today? Affidavit मंगा लीजिएगा. All right. Yes.
Item number 2 of daily list for orders.
Please, my lord.
Yes.
So, my lord, I have an application for condonation of delay.
The delay is significant, Mr. Gonzalez.
Yes, it is. It is.
Delay
But
is
I have to,
huge.
yes,
Absolutely. And ignorance of this order probably would not be a good defense. That's what.
I'll show you
can
my
see.
reasons, my lord. Yes, I
Yes.
understand. What I wrote in my condonation of delay is that it was 914 days.
Yes.
But I was mistaken and the registry.
It is 531. It's
531.
531.
So, my lord, I'll show you the material. I'll try and justify this and ask for condonation. And I
Yes.
agree with your lordship that even 531 is a considerable delay.
Mhm.
Now, my lord, kindly start with IA.
Yes, please.
1955, where the appellants are described. 1955. I've asked them to keep it first on top of the list for your lordship.
Yes.
And if your lordships kindly turn to page, I just want to briefly tell your lordships who they are. And at page 7, your lordship will see.
They were not party in the writ petition. That's
No,
what you want to convey.
That's right. I want to.
You read that.
convey-
You read that.
You've
sir.
read
You
that.
read
Yes,
that.
my lord.
Yes.
Now, my lord, if you turn to the next page,
Mm.
background of appellant number 1, applicant number 1.
Yeah, he was injured in the incident.
Yes.
He was kidnapped and injured. That's what you want to
Yes,
say.
that I want to
Yes.
say. And as far as applicant number 2, he
Mm.
is presently a member of parliament, but during the relevant period, he was a journalist covering the secret killings. That is what I want to show your lordship there.
Yes.
So these are persons who have standing, and both were not parties to the writ petition. No victim, in fact, no victim of the killings, no family member was made party. It was directly between the petitioner before the High Court and the government. So,
Right.
my lord, with that, I finish, my lord, this IA.
Mm.
Now, my lord, kindly turn to the condonation of delay. That is, my lord, IA 1778.
Yes. Yes, please.
Yes, my lord, give me a second, my lord.
Mm.
And I've described, my lord, how the Sakya Commission came about, but your lordship seems there was the Sarma Commission, and then that term came to an end.
There were two commissions. One of honorable judges opted out. Then there was a second commission. It
Yes.
gave its report. Government was not satisfied. There was a third commission. That is the Sakya Commission,
Sakya Commission.
which
That's
has been
on the
quashed. Which has
that's
been
on-
quashed. Yes.
Yes, my lord.
Yes, please.
That's on the merits of the case. If your lordships allow me after finishing.
No, not the merits, sir. Not at this
No, sir.
stage.
I'll do condemnation of delay only.
Yes.
Now, my lord, the important thing here is at page 8, paragraph 4,
Yes, please.
that after the impugned order was passed, I went directly to the Supreme Court. That is paragraph 4.
Yes, please.
And my lord, the order of the Supreme Court is on the last page,
Yes, sir.
page 11.
Yes, please.
Permission, your lordship has seen that. Permission to file special leave petition is granted. Learned counsel appears praised for withdrawal with liberty to file the writ.
File an appeal. But that doesn't mean, or that doesn't imply that your limitation would be condoned.
No, I'm not saying
because
that, sir.
The permission was granted.
No,
Yes.
no, I don't want to say
So
that.
now, sir, please look at your grounds in the application seeking condonation.
Yes, the application seeking condemnation
Yes, please.
is, my lord, very cryptic.
Yes.
And
To say the
therefore,
least.
No, it is, yes. I agree with that. So I filed, my lord, the additional application for additional affidavit in support. And that is dated, my lord, 2/11/21. So there are two affidavits that follow, 2/11/21.
Yes, please.
Now, if your lordship turns to page 13,
Yes.
paragraph 3, I said that I was not a party. So I remained unaware for some time. But paragraph
then
4,
again-
I set out that I didn't
Yes.
manage to get the papers. It was very difficult
Sir,
to get the.
issue is,
Yes,
para 4, if you read of your additional affidavit, when
Yes.
did you find out about the order? What was the date?
I think I've said it, my lord. Let me just,
Read, sir.
yes, I just. So these are, just let me finish this, my lord. These are the documents I had to get. Then in paragraph 6, I say I was unable to get the documents.
Sir, before we reach that state, when
Yes,
did you find out about the order?
give me a second, my lord.
Yes, please.
That will be paragraph 10.
Not para 4.
1 second, my lord. I haven't stated it in para 4, but para, I think, 10.
Then, all right, sir. 10, let's see the date. Any relevant period mentioned in it?
In paragraph, my lord, first I say I had to get these documents. Then para 6, I say I was unable to get it. Then it took several months for the appellants and legal counsel to obtain the above mentioned documents. Then in paragraph 10, I say it took few months for the appellant. Then I found appellant number 1. because I wanted some.
There are no dates, no months, nothing at
Maybe,
all.
my lord. I'll just see in the subsequent affidavit. Give me a second.
That is what we are reading, sir.
Yes, no, this
Probably
will be, there's
we'll have to
another
file-
affidavit as
We'll
well.
have to file yet another one.
Yes, my lord. So, my lord, this does not give the exact date when I came to know,
This
but I'll tell
doesn't
you,
give, this doesn't give anything, sir.
this gives, my lord, the reasons why delay took place in getting documents. And then, my lord, the delay to get appellant number 1 as a party, because I wanted to get a person who was directly affected for locus standi and so on. So, my lord, this sequence led to some delay. Now, my lord, I filed another affidavit.
When is that, sir?
Is the rejoinder affidavit in which I give further details. December 2000. Kindly see the rejoinder affidavit, my lord. See para 4, my lord. I'll just read this, please, in case you.
Just hold on, sir.
Yes,
Hold on, please.
yes.
We don't find your rejoinder affidavit anywhere. Is it available?
Rejoined.
When was it filed, sir?
Filed in
when was it?
2022.
When, sir?
June 2022.
June 2022.
Yes, sir.
Rejoinder affidavit 32 to 43.
Yes.
36.
Yes, sir. So in paragraph 4, my lord,
Yes, please.
we were not parties. Turn over the page to page 37. They were naturally not aware of the regular developments, especially one that took a decade to be decided. So it got buried really in the backlog and huge burden on the court. That is why they did not immediately become aware of the impugned order. Furthermore, there wasn't much discussion in the media about the impugned order. Even the respondent number 1 has submitted copies of 2 newspaper publications, both on the 4th of September, which I missed because I was traveling at that time. So, my lord, apart from that, there was not much that the public would make. And I was traveling. Now see here, my lord. Appellant number 2 was traveling around the time the impugned order was passed. He became aware about it only in December 2018. Thereafter, he reasonably expected state of Assam, which had sanctioned the psychiatric.
So they have the fact that the appellant number 1 came to know of the order in December 2018 is admitted. When
Yes,
did you
sir.
apply for the certified copy, sir, of the order? You, before going around fishing for the other documents, the first step, if anyone wanted to file an appeal, would be to procure the certified copy. Your
Yes,
certified copy was
that-
applied in February 21, which you have placed on record of this appeal. Maybe in the one you filed in Honorable Supreme Court, that would be earlier. But again, you started your proceedings for filing the appeal in June 19. So 6 months clear gap even from the knowledge.
Yes, bro. So I'll just read this and tell your lordship why that gap is there.
Yes.
And that perhaps, my lord, I'll try and say that it. Thereafter, he reasonably expected the state of Assam, which had sanctioned the commission, to appeal against the impugned order. However, when the state of Assam did not file an appeal for a number of months, appellant number 2 sought legal assistance to file an appeal against the impugned order in June 2019. So I wait for some time because I expect it was a state commission. The state would file an appeal. There was talks, general talks that they would. But when I found that they did not file,
Sir,
I
your
waited.
client has pleaded ignorance. How could he say that there were general talks that appeal would be filed?
No, my lord, when I heard that this order had been made, I
Yes.
inquired and I was told that it is most likely that the state would file because it's their commission. They would be
Yes.
anxious to sustain that order of that commission. So I waited for 2 months, I say a couple of months. And then, my lord, I start making preparations to get all these documents and so on. Then, my lord, from June 2019 onwards, I consulted counsel, began preparing the appeal. It took several months for the appellants to obtain the relevant records since they were not parties to the writ petition. Then, my lord, I told your lordship that I wanted to get a person who was affected, and thereafter it took the appellant number 2 reasonable time to identify the present deponent to be co-petitioner. Further, my lord, the applicants, then, my lord, I talk about the Supreme Court, etc., etc.
Mm.
Then, my
Right.
lord, in March 2020, COVID intervenes. So there was some delay in filing in the Supreme Court, which the Supreme Court, my lord, did not make an issue about. And that is how the appeal was listed. This is the Supreme Court proceedings. And then even paragraph 5, my lord, relates to that. Then, my lord, paragraph 6, where I say 914 days.
Yes.
Then on paragraph 8, the deponent begs to, the applicants had initially approached lawyers in Delhi, and that delayed matters. In delayed manner is not correct. So the actual typing is it delayed matters.
Mm.
There was difficulty in coordinating the procurement of documents. Many documents still could not be procured. And as I said earlier, some of them were illegible, so I had to get that, my lord. And that is, my lord, the rejoinder affidavit. Then, my lord, the counter affidavit of the state is dated 17/2/22. And, my lord, there they say there were 2 publications. That is at page 30 and 31. So I ought to have known.
Yes.
Yes. To which I say, my lord, this was actually missed by me. It was on one day where 2 newspaper reports. In any case, I was traveling in that period.
It was not on one day, sir. The Telegraph is on 4th September, Indian Express 11th September, and Hindustan Times 4th September.
I see. In my
Sentinel,
copy, yeah, in my,
Sentinel is 5th September. These are all the newspapers they have annexed.
I see. In my copy, I only have 30 and 31, unless your lordship
No,
said.
they have filed an affidavit in opposition. Have you got a copy? 15/6/22.
Yes, just a second.
With that, these newspapers are there. So all your suggestive measures of ignorance, they don't seem to have any foundation, sir.
So, my lord, that is what I have to say on condemnation of delay.
Yes, please. Very well. Okay.
Grateful.
What do you say, sir? What is the hesitation in getting the matter examined on merits? Hmm. Hmm.
I can't hear, my lord, at all. There may be something.
There's a mic, please.
Yes.
Yes.
And my lord, in second, my lord,
Grateful.
there are additional affidavit, my lord. What they have stated, my lord? They stated, my lord, applicant number 2, my lord, could not contact applicant number 1.
Hmm.
And my lord, that their voluminous document is there. That is the ground they have, my lord, delay of filing of the appeal.
Hmm.
In third, my lord, rejoinder, my lord, what they have stated, my lord, is applicant number 2, my lord, prevailing. Because prevailing, my lord, he only came to know 2018, December 2018, my lord, they came to know.
Hmm.
They had no specific in particular grounds regarding the delay, my lord. And by 3 different applications, my lord, they stated that these different got only to improve their cases. And my lord, what I submit before your lordship, my lord, that Mohinder Singh Gill case, my lord, a case cannot be, my lord, improved by filing affidavit. Here in this case, by various applications, they want to improve the case that on these grounds, we could not file the, my lord, application. And there is one, they are not one, this is not a 500, my lord, for 31 days, my lord. And judgment was passed on, my lord, 3/9/18. And original writ application was filed 2018. And application number 2, my lord, he is a renowned journalist, my lord. He is now presently, he is a member of the, my lord, Rajya Sabha. He is very much ever, my lord. He's very much connected to this, my lord, this secret killing, my lord, what the term used by the government. Secret, he is very much aware, my lord. I have not believed that he is not aware of this.
Hmm.
And well, after the judgment, my lord, it was published very well, not only local newspaper, in every national newspaper also,
Hmm.
print media also, all have aware of this, my lord.
Right.
They, and my lord, 2018, well, they're waiting up to 2021. And pandemic lockdown start in the month of, my lord, March 2020. And it was came to an only on 2/10/2021.
Hmm.
They have not filed any application, my lord. And in their affidavit, my lord, application, they have not stated anything about the knowledge of the order. Only, my lord, rejoined the affidavit, they stated only in 2018 December, I came to know.
Right.
They have not said anything about the knowledge, date of the knowledge.
Mhm.
Even from the date, even, my lord, taking that date, my lord, 2018, my lord, when they filed a certified copy, they filed, I have found it 2021, my lord.
No, that
They're waiting.
certified, first certified copy, they must have filed in Supreme Court.
Maybe.
This
my lord,
is
maybe,
second
my
one
lord.
from
Maybe,
mostly.
my lord, that maybe that means.
Yes.
But that various government they have taken, my lord. And you know, this is very sensational case, my lord. Everybody aware, my lord. A very political sensational case. Everybody is aware, and it is not unusual that not aware this, my lord. This judgment, my lord. All are aware, my lord. Because only again, my lord, that this petition may be dismissed, my lord. 2018 order, they sell in 2001. Order passed 2018, 3918, my lord. They waiting up to, my lord, 2021, my
You're
lord.
right. Mhm.
And why they have not made a party, my lord? But we have challenged the constitution of the Justice against Soikia Commission and their purported report. And we have not any of the victim, well, no other victim has come, my lord. Because he was, my lord, he was allegation, he was kidnapping and he was allegation attempt to kill, my lord. And the person.
Were
who
there
he
any
killed-
criminal cases registered? Were there cases registered with the CBI in relation to the same killings? No, no investigation at all. No investigation.
No. Criminal case, there were no.
Hmm?
No criminal case, right?
No criminal cases were registered ever.
The criminal case, my lord, they just registered, my lord. Criminal cases registered. Some cases.
Who investigated?
State police.
State police.
State police, my lord. State police. State police, my lord.
Right. Okay. Well, what is the stand of the state? State, did you ever propose to file an appeal against that order? What was the state's stand?
So he can be requested to use the mic. I can do.
Madam, you come this side.
Grateful.
Yes.
Lordship, on that particular point, Lordship, I don't have any instruction on that regarding filing of appeal, Lordship.
Mm.
But in the matter of filing of this writ appeal and along with the prayer for leave for filing the appeal and also the delay of condonation, Lordship. This matter, Lordship, though we have not filed the affidavit in this regard, but still, Lordship, the delay that has been stated, that the ground that has been taken by themselves has not been properly
That
explained,
argument-
Lordship, because each
that
and
ar-
every day's delay has to be
That argument we have,
explained, Lordship, in a
Alright.
proper manner, Lordship, and then only the delay can be condoned, Lordship.
Okay, very well.
And here, whatever has been stated, Lordship, these are, Lordship, just to cover up their stand on that particular point, Lordship,
Very well.
and nothing else, Lord.
All right, arguments heard on the interlocutory application, order is reserved.
Grateful.
God bless you.
And the
Item number 4,
explanation is neither here nor there. Yes. Affidavit of substituted service,
My lord, we have already filed an affidavit, my lord.
Ben,
My lord, that we have filed on 9th of February 2023.
9th February. Have you published the notice?
Yes, we
It's not there, sir.
have enclosed the complete newspapers. It was published in 2 newspapers.
And counsel, your good name, please,
Arbo Pujari.
submits that he has already filed the affidavit in proof of substituted service, ready to check and report list after 1 week.
I'm so obliged.
Filed on 9th February,
9 February.
on 9th February.
Matter number 5,
Yes.
This is regarding loan,
Surface proceedings. Surface proceedings.
my lord.
Why it is maintainable, sir? Why are
Yeah,
it
I
is-
filed before the single judge and single said when it should go to the division.
Yes, obviously, surface proceedings, it can't be entertained by learned single bench, but we are asking you why this writ is maintainable.
I think, my lord, in this case, simply, my lord, I took a loan. I am not against the loan, my lord.
You,
I am a loan.
yes,
I
then,
have 10 loan, amount is 70 lakh. And there is, Honorable Reserve Bank issued a guideline, my lord. that-
then Arupam, give that judgment. Sir, we are asking you a question regarding maintainability of the writ petition. See this judgment of Supreme Court. Yes. See this judgment. Has the bank started proceedings under the Surface Act?
They have, my lord, notional position has been taken.
So then you have to go to DRT. That's the only way out.
There is
Read
one-
the judgment, please. High courts cannot entertain any writ petitions in this matter.
Proceeding now, yes, there is a, now they have taken the notional.
Then
position
all
taken.
right,
At any time, my lord, they made.
you have to go to
Next-
DRT,
next-
sir. That the only remedy is DRT.
My lord, I'll go.
In view of the fact that the petitioner has available to him appropriate statutory remedy of approaching the DRT against the impugned action of the respondent bank, taken by the respondent bank under the Surface Act, we are not inclined to entertain this writ petition on the ground of maintainability. Hence, the same is dismissed as such. Needless to say that the petitioner will be at liberty to avail suitable legal remedy for redressal of his grievances.
With liberty, my lord, to file, approve the.
We have given you that.
My-
The writ petition is disposed of with the above observation. Interlocutory application is also disposed of.
Master.
matter number 7,
Yes.
May I please, your lordship? My lord, there's a delay of 22 days for preparing this active law.
How many days?
22 days.
This is single bench has interfered into a statutory notification. Why is challenged? Would not have done. Issue notice, no, the notice is served,
No.
issue notice of the interlocutory application to the respondents. Respondent number. There is only one respondent.
Only one.
Respondent number 1, the others are pro forma.
Yeah.
Steps for service be taken within 3 days. Rule is made returnable in 4 weeks thereafter.
Oblige.
matter number 8 for fresh admission.
May it please, your lordship.
Yes.
Your lordship, 8 and 10 are the appeal arising from the same impugned order, your lordship. However, your lordship, may I pray for a passover for the kindly order?
Pondicherry University.
Yes.
There's a matter of Sikkim going on before us, same issue. Probably that is regarding the differently able candidate. Yes, all right.
University there, in respect of Sikkim Manipal University there.
We'll pass over for the timing.
Oblige, your lord.
Matter number 9,
May I please, your lordship? Lordship, my senior is on lax for some part of matter, lord. Very adjourn for time being, lord.
Timing, pass.
For time being, lordship.
Yes.
Vice Versa.
Item number 11,
Made to your lordship.
Yes.
This matter relates to removal of a Gao Panchayat president, your lordship. By way of a no confidence motion, your lordship.
Yes.
And basically, we are that there is a violation of statutory law for which the impugned no confidence motion cannot be sustained, your lordship. In this earlier round of litigation is also there. The petitioner was elected Gao Panchayat president of one Borbon TP in Hailakandi district. And on 5/9/2022, a requisition was submitted by some members seeking for a no confidence motion. At that time, the petitioner being the president, he has to give approval. He gave approval to convene the meeting on 19/9/2022. Now, if your lordship sees the Assam Panchayat Act, your lordship, as per section 15, your lordship, if the no confidence motion is against the president, then it is the vice president who should decide over the meeting. Unfortunately, in the Gao Panchayat, your lordship, there is no elected vice president. So a problem arose as to who should convene the meeting, since the motion is against the petitioner who is the president, and he has also given permission to convene the meeting. Section 15, your lordship will see,
Yes.
every president or vice president shall be deemed to have vacated his office forthwith when resolution expressing want of confidence in him is passed by a majority of 2/3 of the total number of members of the Gao Panchayat. Such a meeting shall be specially convened by the secretary of the Gao Panchayat with the approval of the president of the Gao Panchayat. Such meeting shall be presided over by the president if the motion is against the vice president, and by the vice president if the motion is against the president. Now, admittedly, in this Gao Panchayat, there is no vice president, your
So
lordship.
that means no confidence motion cannot be brought or what?
It can be brought.
Then
but,
the secretary would be there.
So he asks the
Secretary, it is a clerical job which is to be done.
So far as the presiding over of the meeting is concerned, your lordship,
Yes.
that has to be done by the vice president. So since there was no vice president, he asked the secretary to wait for some time so that a vice president in the meantime can be selected. Now, the secretary referred the matter to the Anchalik Panchayat,
Yes.
and on 18/9/2020, on 22/9/2022, secretary referred the matter to Anchalik Panchayat. On 26/9, Anchalik Panchayat convened a meeting fixing date on 27
Yes.
in blatant violation of the statutory provisions, your lordship. That was put to challenge before this honorable court by way of an earlier round of litigation. And this honorable court, your lordship, by the order dated 4/11/2022, page 82, finding violation of the statutory proceedings, set aside the no confidence motion and directed that the relevant is at page number 84, your lordship.
Yes.
Directed that no confidence motion should be initiated as per the act, your
Okay.
lordship. Page number
Yes.
84.
All right. So it was interfered. Then what?
Then, your lordship, the Anchalik Panchayat secretary issued again issued the notice for convening a meeting, your lordship. And under the act, if your lordship says,
6 months.
lordship,
Your argument is of 6 months. There's a full bench judgment of this court.
not on 6/1, your lordship, there is a, if your lordship seeks the section 15 for a moment,
Yes.
in case such a meeting is not convened, I have read
Yes.
again, in case such a meeting is not convened within a period of 15 days from the date of receipt of the notice, the secretary of the Gao Panchayat shall within 3 days refer the matter to the president of the concerned Anchalik Panchayat, who shall convene the meeting within 7 days. So there are two requirements. It is the president who shall convene the meeting, and he shall convene the meeting within 7 days. In the instant case, it is found that the meeting was convened at the instance of the secretary of the Anchalik Panchayat, who has no role under the act at all. And your lordship, by way of a judicial pronouncement, it has been held that Anchalik Panchayat secretary can convene a meeting, provided he is duly authorized by the president. But my submission is that, your lordship, he was not at all authorized. And in fact, they have tempered the record to show that there was an authorization. If your lordship sees the record and if it is available with the authorities, your lordship, there was no authorization. If there is no authorization, the Anchalik Panchayat secretary has no role, no jurisdiction under that.
How this argument has been dealt with?
Lordship, it is at page number 134.
Para.
Paragraph number 12. Page 134.
Yes.
The records go to show that after the order dated 4/11/2022 was passed, the matter was placed by the respondent number 5, who is the secretary, to the office file before the respondent number 6.
Yes.
By bringing the order dated 4/11/2022 to the notice of the respondent number 6, The respondent number 5 requested the respondent number 6 to fix a date of the special meeting to be convened for the purpose of discussing the motion of no confidence. The respondent number 6 had thereafter, by endorsement in the official file, requested the respondent number 5 to convene the special meeting on 29/11/2022. Thus, the action of the respondent number 5 in signing and sending the notices notifying the date of special meeting pursuant to the decision taken by the president to convene the special meeting is to be considered only a ministerial act. Now, our submission is that there was not at all authorization. Subsequently, the record has been manipulated. If your lordship sees the record, it will become clear, your lordship.
You should have filed an FIR then. Why are we required to go into the record now? That would be examining as if we are appreciating evidence that there has been a fabrication. Why a writ court is supposed to do that? And now you are in an inter-court appeal.
Lordship.
What is the error apparent on record in the order? Show us.
And secondly, your lordship, because this is from an open eye, from a simple eye seeing, it can be found that it is being tempered.
Why
your
should
lordship.
we do that, sir? File a FIR for that purpose.
That can be done, your lordship, but that will not help us in this matter, your lordship. That is a criminal investigation may start, your lordship, and we can file even today also, your lordship, but we will not be having any relief. So the assuming of jurisdiction by the secretary was, lordship, without any in violation of the law, your lordship.
So if there is an authorization, there is no violation. That's not disputed.
That is not disputed.
Right. So the fact is that whether there was authorization or not, that is a pure question of fact now. So for that question, disputed question of fact, why it should be entertained? It's your bare bald statement that it is a fabricated document without there being any supporting material. The document was allegedly created in November 22. What steps have you taken to question the validity thereof?
Not in November, your lordship. That this latest meeting was held on November 20. Because only when the matter was placed before the single judge and the matter we could see, single judge has
The
given us to
reply,
see.
the
Then only we come-
affidavit must have been filed wherein this is the evidence must be there that there is an authorization. So what did your client do thereafter?
In the affidavit also says there is no such.
Read your averment, sir, first in the writ petition. And their affidavit wherein you said that it is without authorization. What is their affidavit to that allegation in your writ petition? Where is your ground
Lordship,
in the writ petition?
in the writ petition,
Yes.
lordship will find it.
Para 14.
14, your lord.
And now what is their response to this para?
The affidavit is at page number. No, it starts from page number 95.
95. Read, please.
Paragraph 5, your lordship, they have stated that with regard to the amendments made in paragraph 11-12 of the writ petition, the answer and deponent beg to state that the question of violation of the statutory rule by holding the meeting after 13 days instead of 7 days be considered in the light of judgment passed in Farhana Begum Lashkar. So far, your lordship. Paragraph 6, they have stated that with regard to the advertisement made in 13 and 15, the answer and deponent begs to state that as per provision of law, the meeting is to be convened by the president of the Anchalik Panchayat. In the instant case also, the meeting was convened by the president and the notice dated so-and-so was issued by the secretary and executive officer of the Lala Anchalik Panchayat as instructed by the president, and the president has presided over the meeting.
So you were present in the meeting.
On
You
that
were
meeting-
present.
On that meeting, I was not present.
President has presided over the meeting on the 29th.
President has presided over the meeting,
So president means the appellant,
not the appellant, your lordship. He is the
Then-
president of Anchalik Panchayat.
Anchalik Panchayat.
Anchalik Panchayat.
All right. So where is that authorization you are referring to?
That is,
Is-
they are saying that it was instructed by the president. to the
Where is that?
secretary.
Where is that?
At paragraph 6 of page 99. Their state is that the president has instructed the secretary. Page 99, paragraph number 6,
Hmm.
that with regard to the amendments made in the paragraph 13. and
Instructed
15,
by the president.
president. President means the president of the Anchalik Panchayat,
Yes,
who was supposed to convene the meeting. Now their stand is that
the president has authorized.
has instructed him.
So, and the president was present there.
Present there and your lordship, he presided over the meeting.
He is presiding. His presence makes the authorization redundant otherwise also. Anything else to say, sir?
So first, there is violation of 7 days that is not out. It is not a mandatory
Dismissed.
requirement.
Thank you.
Obliged, Lord.
Matter number 13 for fresh admission without stay.
Matrimonial appeal, madam.
Yes, against,
Against, my lord, file petition for restitution of conjugal right. That was, my lord,
that was
dismissed by the court. Husband before the
husband filed the application for restitution.
restitution of conjugal right. Admittedly, my lord, she refused to, my lord, but still the grounds.
She doesn't want to live with you. What can be done?
Even,
Even if there is a decree,
my lord,
whether that can be executed. Why is, what is the point of this litigation?
my lord. Here, your
Try and
lordship,
convince her to come on her own.
no, your lordship, she said, because of my father's problem, she is not willing to, my lord. She has nothing, she did nothing stated against me, man. So is it acceptable?
You are alleging that she took away the ornaments and money.
But in her
Her
written statement.
father-in-law's conduct, she has made an
Your
allegation
lordship,
of
kindly-
molestation.
Kindly peruse page 31
Yes.
in her written statement, madam. What
Mm.
she has stated, in order to justifying her, my lord, paragraph 7,
Mm.
page 31. So the very shortly, the defendant found. the-
Molest, that is what the allegation is. That her father-in-law tried to
Yes.
molest her.
But law, nothing against me, man.
Maybe, but
But
you are residing with your father.
Because of.
You are
the-
residing with your father
There may
and
be.
she feels insecure. You should have offered that I'll take up a
Yeah.
separate residence. Did you make any such offer?
At this stage, my lord, may I pray, my lord, if at this level, my lord, some mediation can, because. notice may be-
All right, issue notice to the respondent. Send for the record.
Obliged.
Steps for service be taken in 7 days. Process be issued, rule is made returnable in
Madam.
4 weeks thereafter.
Matter number 16
May it please, Lord. Lord, the petitioner, the furniture shop, my lord, he avails CC cash credit limits
Hmm.
of up to 25 lakhs, my lord. For the reasons, my lord, because of some difficulties, could not continue with these things. Then the opposite party has declared that an NPA, which it's not came to my knowledge. Thereafter, my lord, they issued notice under section 13(2), my lord. And also, my lord, they have taken symbolic positions. Now, my very limited prayer is this, my lords. Only things I do not want anything except the documents which, so that I can file a reply to that 13(2) notices, my lord.
So ask them for the
Well,
documents.
I have asked, that is why I have.
Where,
come
where
to
is
the-
your application?
My lord, application was not there. I have stated in my,
Then-
I have stated my petition, my lord. Only things, my lord, were the statements,
Where is your application to
My
the
lord,
respondent? Give me the documents, please.
my lord, application, I have not, I have
There's
mentioned in my.
nothing, sir,
I
nothing.
have mentioned in my petition, only thing the documents, my documents, which is
Sir,
lying. in
you
my-
never made any request.
No.
Where is your application?
My lord, I have stated application, I have not been enclosed, my lord, I have stated,
Are you having it, your file? Show us.
my lord, I have stated.
What
in
is
my
the
pa-
date on which you made the request?
My lord, I
Read.
have- my lord, date has not been, my lord.
Sir, so there is nothing and yet we should entertain your writ petition.
Only things, my lord, what I want, my lord, I want only
This
the
is-
things this,
Frivolous, sir, on the face of
my
it.
lord,
You want us to dismiss it with cost
my lord, not.
or
my lord,
what?
My lord, what I want, my lord, only things, my lord, so far, my lord, so that I can file a reply, my lord. That is the only things, what I asking, my lord, from the bank, my statements, my police letters, my approval letters, these are the things so that I can file, my lord.
So you are required to go and make a request to them.
I have,
You not even made a request.
Malad, I have,
Come straight off to the
Malad,
red court.
I have, no.
Read from your pleadings that
Malad, I have.
you
pleading,
made a
Malad, your
request.
lordship
In
will
what
find-
form?
Malad, later your lordship will find page 32, Milord. There's a letter which I have been given page 32, Milord. 30, Milord, your lordship will find page 30, Milord.
Yes.
My lord, 3/1/2023. I am in receipt of your notice addressed as however, it appears to say notice that I have been issued without considering the entirety of the facts, the circumstances to which I have been subjected, and furthermore, the record of the pertaining aforesaid so-called the cash credit facility have not been given to me. Inasmuch as I do not have any have a sanction letter with me. And as such, due to the non-availability of the requisition documents, I am unable to properly reply to your aforesaid notice. Hence, that I am submitting my interim reply. So that is what I have stated, Milord.
Sir, what is the date of your letter?
That is at 3/1/2023, Milord.
Your letter. This is the letter which you
I'm-
received. This is date of receipt.
Receive, Milord.
What is the date of your letter? When did you dispatch it? What was the mode of dispatch? This is all created evidence, created documents.
My lord, it's not the created, Milord, sir.
Let us see what is the date of dispatch, or rather even date of the letter.
So, my lord, averments, your lordship will find page paragraph 5 and 7, Milord, are the averments which I made on oath, Milord. That is,
What is the date of this letter, sir? What is your stand, gentlemen?
Hello, the letter doesn't never serve to a bank man.
That is your instruction?
Yes, my lord.
my lord, so far I am concerned, Milord, I have the instruction that I have sent it, Milord.
You should have at least, you are expected to mention the date on which this letter was
Definitely,
dispatched.
Milord, I agree to that.
Nothing at all.
My lord, your lordship may give me, allow me some time and I'll.
1 week.
Right.
All right.
No, I have not received copy, my lord. Copy may be served.
Give a copy of the petition.
My lord.
Sir, the documents only by glancing at the documents, the fact comes out, whether it's a fabricated one or not. Doesn't take much time. These are all created after legal advice.
My lord.
Next case.
Much obliged.
Item number 17.
May I please, my lord?
Yes.
My lord, it's a transfer order. Normally in a transfer order, my lord.
Normally,
Normally in a.
invariably.
But invariably. But
Yes.
my lord would find the difference here, my lord.
Yes.
My lord, this officer, he was, my lord, had joined the railways in 2001. And my lord, this is his fifth
2000.
one. And this is his fifth zonal railway posted, my lord. From 2001 till, my lord, 2022 or 23 now, my lord. This is the fifth railway he has been posted to, my lord.
Mm.
He was posted to, my lord, the NF railway on 1/12/2015
Mm.
from, my lord, North Central Railway.
Yes.
Then, my lord, he was holding posts here. Then he came to Guwahati, Maligaon, my lord, on 3/8/20, and then he was holding a post till 22. Thereafter, my lord, he was posted to the current post from which he was transferred on 17/8/22. Now, all of a sudden, the railway board, my lord, issues the order at page 76, my lord.
Yes.
This is issued on 3/3/23. Sri P.P. Pandey, SAG so-and-so should be transferred to North Western Railway and posted in the cadre.
Yes.
Fine, my lord. Now, at that point of time, he was involved in a lot of works here. And this railway board said,
They'll manage, don't worry.
no, but they can, that's it, they can manage, my lord. But the problem with this man was, his elder son was in class 11
Mm.
and the younger one was in class 10. I'm not going to the youngest one because that's beyond 2, my lord. I'll leave that. The eldest one was in class 11 and the youngest one was in class 10 studying. So next year they are appearing in their 12th and the 10th. So he made a representation, my lord, before the board. That say, this is my condition. And the railway circular requires that if any person is to be posted up, because I came on transfer here, Hut Station, I'm given three choice, my lord, three choice places of posting. And if possible, I have to be considered there. And if not possible, then only I have to be transferred out. I made also an averment that there was no administrative exigency involved in transferring this matter. Nothing happened. I went to the Central Administrative Tribunal. The Central Administrative Tribunal on the first day, my lord, considering the matter, directed the member engineering to dispose of my writ petition. Sorry, my lord, the OA. No, the representation, my lord. And the OA was also directed to be placed before him. And it was placed. Now they, my lord, on consideration of that, they pass an order. They pass an order, my lord, on 10-4, and I get it on 3-4, 13-4. That order, my lord, is at page 74. I'll pray, my lord, will have this, my lord, because that order, my lord, slightly.
No, not an issue. Carry on, carry on.
My lord,
Order of the
my lord,
railway-
it's a wrong
railway-
mistake in filing, my lord.
Railway board,
Railway board's order.
yes.
My lord would-
Underline,
my
all
lord-
remarks are there.
That's why I'm sorry, my lord. Junior, my lord, she was very new. My lord, she filed it. She did not know about that.
Anyhow, she has good handwriting, that's at least. You can give her credit for that.
This is my handwriting. So,
Probably she was inspired by that to file it on record. Carry on, carry on.
my lord would see, in terms of.
Thankfully, none of our orders has been placed in this manner.
No. I'm sorry, my lord.
Yes.
I got to know only yesterday night, my lord.
Yes, yes,
My lord will have para 3, my lord.
yes.
As regards to the schooling of its kids in the academic section commencing in the next academic year, as raised by the officer, the issue has been taken care by issuing an advance order dated 3/3/23.
So the
Providing
session ends in March.
March.
So he can get
My
them
lord-
admitted to
My
another
lord
school.
will see the predicament of me. I'm in class 11. I'll go to 12. The admissions have already been taken in December, my lord. Matriculation, I have taken admission in December. Course is underway, my lord.
Mm.
Now, how can I take my student there? Their registrations, everything is here, my lord.
Let
my
him
lord will
stay
go-
in a boarding. Let him stay in a boarding.
No. 10 and 11,
Bad
11 and
place.
10, the problem, my lord. Class 8, 7, there was no problem. I could have taken them. But 11 and 10, my lord will see further. My lord, the issue was something else. My lord will see the administrative exigency, my lord. Now, my lord will see 4.
Mm.
Officer has been working in the Northeast Frontier Railway for more than 7 years. There are 20 years, my lord, minimum 10 to 20 years people working not touched. I'll show, my lord. Earlier, while working in the selection grade so-and-so, he was transferred to the Northeastern Frontier and working here since 1/12/25. As per Railway Board's comparison policy, which entirely lays down normal tenure on a particular post,
Mm.
my lord, not the zonal railway, but particular post, at a time will be 2 years and maximum tenure 5 years. However, in administrative exigencies, fine, my lord, relaxation may be granted to any of the provisions contained in this policy. Now, my lord would see. It is an established law that transfer is an incidental service and employee working on a transferable post cannot claim. As a matter of right, he should be retained in a particular post or at a particular place. It is a choice of the employer to determine how long the services of an employee is required in a particular post or at a particular place. The order transfer does not affect any legal rights of the employee. The officer is a Group A officer belonging to Indian Railway Service of Engineers, which has been primarily entrusted with the task of handling railway infrastructural projects and other safety related work and liable to be transferred to any project railway in administrative exigency. My lord will again mark the word administrative exigency. See, PP Pandey has been posted against a clear vacancy. Now, my lord. 7. As regards the contention that exercising 3 options citing reference of board's letter, it is clearly to be understood that essence of the letter lies in favor of those officers who want to go out of NF Railway themselves after serving 3 years. The instant case is not covered under the purview of the said instructions as the officer has completed more than 7 years and he has not exercised any option 3 months prior to completion of the 3 years from the date of joining in so-and-so. Therefore, the same cannot be considered at this stage. As regards family life, my lord, I'm leaving it. From the above, it is clear that the transfer order of so-and-so from NF Railway to Vasta has been issued in administrative interest due to administrative exigencies and due care has been taken to ensure that his children's education is not affected adversely. Now, my lord, they use the word administrative interest and administrative exigency. But my lord, they have not even whispered as to what the administrative intention.
They're not supposed to
Because,
show
well,
that in every order, they may have n number of uses for the gentleman. in the southwestern railway.
Lordship, that's what I wanted to, my lord, point out before your lordship.
Yes,
Now, my lord may come to page 55, my lord,
yes,
of the writ petition.
yes.
Now, my lord, if it was a case that the qualities that I have, my services would be better utilized in Southwestern Railway, my lord will not even allow me to open my mouth, my lord.
Yes.
If that was not the consideration, my lord.
Mm.
My lord will read this. That to your knowledge, that applicant begs to state that is within his knowledge that the respondent number 3 had sought for the status of the work done by the applicant during the past 6 months. And to that effect, the controlling officer of the applicant, that is so-and-so, white communication bearing number so-and-so dated 14/3/23 has communicated the status of the work done by the applicant for the last 6 months. The applicant categorically states herein that the communication dated so-and-so, the controlling officer had submitted that the work stated to be undertaken by the applicant in so-and-so and so-and-so are factually correct, and the same are being carried out for more or less as per target. Now, this was asked for, my lord, after the order passed by the Central Administrative Tribunal. So when the original order was passed, this consideration was not there, my lord. So, my lord, how now, my lord, the tribunal has considered the matter.
Yes.
My lord would have that at page 116, it starts. If my lord just cursorily passes through the paragraphs,
Yes.
my submissions were recorded at paragraph 9, 121, the submission of the learned, my lord, counsel appearing for the respondents was recorded. And thereafter in para 11, certain judgments where, my lord, citations were given. And then my lord would find at page 123, after the citation, transfer is an exigency of service and is administrative decision. The courts and tribunals are not appellate forward to decide on transfer of officers on administrative ground. The wheels of administration should be allowed to run smoothly, and the courts or tribunals are not accepted to interfere in the working of the administrative system of various. In the light of the above, I find no reason to interfere. My lord, no conclusion arrived at with regard to the facts which were placed before the honorable tribunal, my lord.
Transfer matters. Nair, you yourself know how much is the scope of interference.
And my lord would see the manner in which they were working. But I'm not saying, I'm only saying, and lordship would see how the, my lord, discrimination is being meted out. If my lord can have the additional affidavit, that is fine.
Transfer, what kind of discrimination you can plead?
No, my lord, not the discrimination, the application of mine, my lord.
You just
My
said
lord, will say there
discrimination.
was a person called Pranab Kumar Sharma.
Yes.
My lord, I filed a writ OA. I was not relieved. I filed an OA at 1:30. Now, evening 5:30, I'm giving the relieving order. So that, my lord, no interim order is passed.
Mm.
Now, when I file the writ petition, what they do is, my lord, they fill up my post through one Pranab Jyoti Sharma.
Yes.
On, my lord, fine, very good. But my lord, who is this Pranab Jyoti Sharma? He was under order of transfer to, my lord, Eastern Railway on 24/5/22. And that same very authority, my lord, granted him with effect from 15/7/22 a year stay here, extension. For some reason, he might have shown, my lord, extension was granted.
Mm.
Now, to just block any orders that may be passed by my lord,
Yeah.
they issued this
Yes.
order, which I brought by way of an additional affidavit. Now, my lord, I'm only praying next year after my children's education, anywhere I'm ready to go.
Not the scope of writ jurisdiction, Mr. Nair.
Understand, my lord, understand. But my lord, every transfer order,
Yes.
my lord, is not, my lord, for the reasons it is projected, my lord. At least the tribunal could have gone
Sam,
behind,
You know, we'll let you know of an incident.
lordship.
There was a professor in the IIM who was transferred. The matter went to the Supreme Court. And Honorable the Supreme Court observed that the employer doesn't want to see the face of your client. That can be a ground of transfer. That's how transfers are. See, he has
But
been
my
here
lord-
for 7 years, sir. That's good enough.
No, my lord.
You should
if I-
feel happy now.
No, my lord, if I have put in 7 years, one benefit, my lord, they should have given to me. That my lord would find in the orders, which were one of the circulars. and
What
all,
benefit? You will be getting the benefit of transfer allowance. What else?
No, my lord, that's there, my lord. But my lord would see the predicament of my family, man.
March.
In fact, Lordship, my instruction is, Lordship, he's worried about his children. They can retain their quarter here. Very
Oh.
My lord will pass that order, my lord.
All right.
My lord will pass
Very
that
well.
order.
Retain the quarter till when?
till the next.
Till the academic session is over, my lord.
All right.
My lord,
In view of the petitioner has questioned the,
my lord will
order
not
dated
put
so
it in
and
my
so.
mouth. Let it be his submission.
yes, yes. All right. Order passed by the learned tribunal whereby, the original application preferred by the petitioner seeking to question the transfer order dated 3/3/2023 was
And-
dismissed.
And the speaking order.
And so also the speaking order dated so and so. The primary grievance of the petitioner against the impugned transfer order was that his children's academics, the academic sessions of his two children who are studying in the 11th standard and the 12th standard,
And
10th standard respectively have commenced, and if they are disturbed at this point of time, their entire educational career would be put to stake, as they are at present, on the cusp of the formative years. Deputy SDI, Mr. Chaudhary, submits that he has received instructions from the authorities that in order to take care of the education of the children, the petitioner can retain the quarter at Maligaon, where he is presently staying till the academic session, ongoing academic session ends. That would be somewhere in the month of March 24.
24.
March 24. In view of the statement so made by Mr. Chaudhary, the Senior Counsel, Mr. Nair, takes liberty to withdraw the instant writ petition.
My lord
This
will
is-
dismiss it. My lord will dismiss it. I'm not coming. My lord will
all right,
dismiss it.
dismissed. Dismissed. In view of the statement so made by Mr. Chaudhary, all the apprehensions of the petitioner regarding his children's education being adversely affected have been set to rest, and hence, there is no reason to interfere. Dismissed. Have been ventilated. Okay.
Letter number 18.
My lord, here, my lord, the challenges made to the order passed by the learned in this tribunal, by which the tribunal has, my lord, stayed the order of transfer. My lord, the earlier matter pertains to the same issue, my lord. The impugned transfer orders are same. That is March 14/3/2013.
Again, hardship for the family, school education, get him served,
That part will take care of.
issue notice, get him served, then
My lord, my lord,
issue notice to the respondent.
my lord.
Steps for service taken in 3 days. Rule is made returnable on. How many days would you require?
2 weeks.
Dusty service?
Dusty, my
Dusty
lord.
service is
1 week.
permitted. Rule is made returnable on 24th May.
My lord. God bless.
Keep a copy of the other order handy on the other day, next day.
My lord. God bless you.
Letter number 19.
My lord, on last occasion,
Notification is there. There are ESI courts in Guwahati.
yes.
Then you have to approach there, sir.
But even though, my lord, so far the alternative remedy is concerned in this.
Statutory, it's not alternative. This is a
Yes,
statutory remedy.
statutory.
And
But
see this
even though
judgment,
whatever-
see this judgment of the Supreme Court. The southeastern. See this judgment, sir.
My lord, your lordship will come to the observation made by the learned single judge. If once your lordship will come, that your lordship will find at page 39,
Yes.
page 39. Para 21.
Yes.
In the backdrop of the above reasoning, the extension of the ESI Act to cover the educational institutions
Yes.
through the impugned notification such is found to be in order, and accordingly the contention raised by the petitioners to the contrary are rejected. However, that is important, my lord. However, since the operation of the impugned notification was stayed by this court, it could be applied prospectively to the educational institutions, and no school should be forced to subjugate themselves retrospectively under the ESI Act. It is ordered that.
Mm.
This being the position, my lord, this petition was filed, my lord. And accordingly, the order, which is under challenge, your lordship will come at page 41. Relevant portion is at page 43.
Mm.
last paragraph, my lord.
Yes.
I have carefully perused the judgment and respectfully concur with the findings arrived by the coordinate bench. However, the findings of the coordinate bench in para 21 of the judgment that the operation of the impugn notification, in my respectful opinion, cannot be made applicable in all cases. This finding is perverse, my lord. Because
Obviously,
this finding is perverse, my lord.
why perverse, sir?
Because if your lordship again, for this one, again I'm taking to your lordship at page 40, my lord.
Hmm.
Last one. It should be applied prospectively to the educational institution
Hmm.
and no school should.
But is it your case that is this notification is being applied retrospectively to your school?
Yes, that is my case, my lord.
Why?
Because they demanded the contribution for the period from June 2011 to September 2014.
So when was the notification is of 2009? How is it retrospective?
Yes, 2009.
Then
But once it was stayed by this honorable, by the single judge of this honorable court, my lord, in that case, my lord, the judgment is applicable and it applies in rem. And if your lordship relegate me to the alternative remedy of filing the application under section 77
Hmm.
of the ESI Act, my lord, in that case, what would be decided?
Yes, Mr. Counsel, what do you say?
There's a difference of facts when regarding the earlier case. The earlier case was filed challenging the notification whereby the act was extended to the educational institutions.
Right.
But that was dismissed by this honorable court.
It was dismissed, but with the observation that as the notification had been stayed,
My lord,
it should be applied prospectively.
my
So if
lord.
you go for prospective application, by that time, the school had already been closed. So what would you get? What would you recover? So for the corresponding period, the notification was stayed.
My lord.
How can you ask for a recovery?
Here, my lord, in my respective submission, my lord, the petitioners needs it should be applied to the ones who have challenged the petition, the notification, my lord, not all the school. I mean, that was our understanding,
Notification, this court has already made it clear.
my lord.
Now, what you can at best argue is whether that order has been challenged, the one he is relying upon. If that order has not been challenged,
Hello.
its effect is in rem to all institutions.
Hello.
Then
And one, that is there, but that is, the lordship decide the matter, my lord, regarding this.
Hmm?
My lord, one more difference is, my lord, the challenge is with petition is regarding to the recovery notice, my lord, not the, so that page number 39.
they are saying that recovery could not have been effected
My lord.
or recovery notice could not have been issued because the notification under which you are proposing to effect the recovery has been held to be prospective in nature by order dated 2000, that is of the year 2016.
16, my
And
lord.
this recovery is for the previous period.
My lord.
Have you filed your affidavit in the red court?
My lord, no, we're not.
No.
No, it was an in limine, it was dismissed.
Hello.
All right. Issue notice, Mr. So and so puts in appearance on behalf of the respondents. Then Counsel Mr. Bhatti submits, has referred to the order dated 1st February 2000. Order dated
28/1/2016.
28/1/2016, passed by Leonard Single Bench of this court in WPC number 4121/2009, whereby, it was held that whereby, the notification dated 6/1/2009 covering the educational institutions under the ESI Act. ESIC Act was affirmed, but a direction was given to apply the same prospectively to the educational institutions as the notification had been, in view of the fact that the notification was stayed during pendency of the said petition. What Learned Counsel submits that in view of the aforesaid pronouncement of this court, the appellant herein could not have been subjugated to the effect of the notification because the recovery which has been demanded under the impugn notice pertains to the period between June 2011 to September 2014, which would be prohibited by virtue of which is impermissible by virtue of the above judgment. The matter requires consideration. Thus, the respondents' counsel are given liberty to file their affidavit in this appeal because no pleadings were filed in the writ petition. In the meanwhile, recovery shall not be effected from the appellant pursuant to the notice annexure.
Annexure, my lord. Just a minute.
Dated notice annexure so and so dated 30th June 2015. 30th June,
Yes, ma'am.
that is the notice. Order dated 30th June 2015, annexure so and so.
Much okay.
In response to the observation made by this court on the previous date of hearing, then counsel Mr. Bhatti urged that the instant writ petition has been filed. Primarily, instant appeal has been filed to give benefit, with a prayer to give benefit of the judgment rendered by coordinate bench of this court in so and so. However, as the learned single bench has concluded that the said judgment would not be applicable to the appellant, it would not serve any purpose if the appellant is relegated to approach the ESI court constituted under section 74 of the ESI Act. Then you the remaining part. Yes. Next.
Matter number 21.
Made vigilance.
Yes.
Lord, the issue involved in this case is promotion to the grade of assistant executive engineer, my lord, in the Assam Pollution Control Board.
Mm.
Now, what had happened, my lord, the writ petitioner, my lord, he is a direct recruit. Whereas, my lord, the appellants before lordships, they were junior engineers, my lord. They were upgraded to the post of, my lord, assistant engineer. And in fact, they were upgraded to the post of assistant engineer before the writ petitioner was even born in the category of assistant engineer.
Mhm.
And those orders of upgradation and the, my lord, fixation of pay and all were never under challenge. Now, my lord, apparently the learned single judge, my lord, taking the view that upgradation could not have further given the benefit of promotion, my lord, has interfered with our promotion. That is how we are before your lordship, my lord. Now, if your lordship would kindly come to, my lord, page number 247, my lord.
Yes.
This is the proceedings of the 75th board meeting held on 19th of June 2001, my lord. And the operative resolution as at page number 251. At page 251 at top, my lord. Upgradation of post of junior engineer to assistant engineer as per Central Pollution Control Board norm. Member secretary apprised the board that as per Central Pollution Control Board, no diploma engineer should be recruited, and the existing diploma engineers should be upgraded from the post of junior engineer to the assistant engineer, aiming at increasing the efficiency of the engineering services of the board in future. Central Pollution Control Board also desired the state board to follow the said policy. The matter was discussed. The board agreed to the policy in principle, but considering the present financial position of the board, it is resolved to upgrade those posts of junior engineer which have confirmed eligibility of the norms phase wise. Board will not fill the present vacant post of assistant engineer till it is decided by the board otherwise. Member secretary of the board will submit service sheets of the upgraded engineers person wise, specifically mentioning the period of qualifying service, the scale of pay, basic pay, departmental proceeding, if any, of the junior engineer for final approval of the board. So, my lord, this is how, my lord, the decision was taken. And if your lordship would kindly come to page 147 is the order, my lord. One 47.
Yes.
This was on 30th of December 2005. Under Rule 22A of Water Prevention and Control Pollution, Assam Rule 1977 as amended, the following 14 junior engineers of this board having experience of more than 10 years of service are upgraded to the post of assistant engineer with immediate effect. Now, serial number 1, 5, 6, 7, 8, 9, 10, 11, 12, and 13 are the appellants before adopted. So, my lord, this is the background, my lord. This was never put to challenge. But our subsequent promotions, which your lordships will get at page number 8, my lord, rather page 109. And the operative portion is at 110. The subpara starting with, after consideration of educational qualification, experience, and ACRs, the committee recommends promotion of the following assistant engineer to the rank of the assistant executive engineer for the position so and so. Dhiren Sharma, that is appellant number 1. So there, my lord, appellant number 1 to 5, these 5 persons. And by another order, my lord, at page 114, my lord. These are the orders. As per the recommendation of the selection committee meeting held on so and so, Dhiren Sharma, assistant engineer, is promoted to the rank of assistant executive engineer until further order. So these are the promotion orders. And 115 is the other promotion order. And my lord, at page 116 is an order by which the services of appellant number 6 to 10 were upgraded to that of the assistant executive engineer, my lord, at page 116. In pursuance to the decision taken in 102nd board meeting held on 9/12/19 under agenda item number 3, and as per approval of the Environment and Forest Department, Government of Assam, while later dated 13th of July 2020, the following assistant engineers are allowed to hold the upgraded post of assistant executive engineer with effect from the date of their joining in their own.
Who are these persons?
These are, my lord, appellant number 6 to 10, my lord, at page 116.
Earlier ones were 1 to 4.
1 to 5.
1 to 5.
Yes,
Okay.
they were promoted and the balance they were upgraded, my lord. Now, all these orders were interfered by the learned single judge on the ground. Primarily,
Upgradation,
my lord,
upgradation was on what basis?
as a person to the, my lord, this policy decision taken by the Central Pollution Control Board, which I have read at page number 247, my lord.
But that was only from the junior engineer to the assistant engineer.
Yes, yes.
Now this is assistant engineer to assistant executive engineer.
Assistant executive.
How that was not the resolution.
No, that was not the reason. Now, question is, my lord, the moment we are upgraded, whether we'll get the further benefit or not. My lord, in service jurisprudence, there is a difference between upgradation and promotion. There is no difficulty in appreciating that.
Yes.
Here, my lord, apparently, my lord, the educational requirements is also relaxed, and moreover, there is a provision, my lord. If your lordship will kindly have a look at the regulation, initially when our services were upgraded, my lord, at that point of time, there was no regulation. It was governed by the air rules, my lord. But there is a regulation. I think on last occasion we had given one copy.
Yes,
my lord.
it is there.
Yes, 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 yes.
Right.
Okay, okay. If your lordship would kindly come to page number 3 of that compilation, my lord, regulation. Please come to my lord, regulation 4.
Yes.
The services of the board shall comprise the categories of post as mentioned in table 1. The board may include any other category of post or post under the service of the board or exclude from the post listed in table 1 as and when felt necessary for smooth functioning of the board and in the public interest temporarily for a period not exceeding 2 years by the board decision on permanent basis with due approval of the government. Members of the cadre shall have no claim for appointment to any other cadre except in accordance with the provisions made in this regulation. 3. Board by resolution may upgrade, downgrade post within the sanctioned strength. However, any addition to the existing strength of the cadre shall be with the approval of the government. So power rests with the board, my lord. However, my lord, because of the financial requirement and all, government's approval is required. Then my lord will kindly come to my lord, rule 7, regulation 7, Roman 4 at page 6. Appointment to the service, I'm reading 1, my lord. Appointment to the service under the board shall be made by the appointing authority by any one or of the more of the following methods: direct recruitment, promotion, deputation, compassionate ground on contact.
So there is nothing called upgradation in
No,
this.
please come to Roman 4, my lord.
Yes.
The number of vacancies under various cadres and their percentage for direct recruitment and for promotion from the next cadre shall be decided by the board authority. Then my lord will kindly come to page number, next page, my lord, page 8. Nine, recruitment and promotion. Then my lord will kindly come to the page 9. Qualification on next page, my lord. Qualification, that is two. Qualification, experience and promotion of employees under engineering and technical service. For recruitment to the cadre of assistant engineer in the board, the required qualification would be bachelor degree in engineering, that is so-and-so, in so-and-so. The educational qualification and experience for the other posts under this service shall be as per table 2 in appendix 2. Promotion from the level of assistant engineer to assistant executive engineer and then to executive engineer shall be on time scale, subject to availability of post suitability, etc., considered by the selection committee. Now, my lord will kindly come to this table 2 appendix 2 at page 33. If your lordship would kindly come to serial number 4, my lord. A statement showing cadre-wise service criteria for initial recruitment and promotion. Serial 4, executive engineer, kindly under column number 9, my lord. For existing promotee engineers, the qualification shall be relaxed to diploma in engineering. Similarly, for serial number 5, my lord. Assistant executive engineer, for existing promotee engineer, qualification shall be relaxed to diploma. Now, my lord, we are diploma engineers, we are not degree holders. Now, the fact that, my lord, we are upgraded in the year 2005 and and so many words, though this does not have evident, my lord, we are rather encadred in the grade of assistant engineer, and by virtue of, my lord, column 9 of this appendix 2, perhaps, my lord, in our case, this degree could have been relaxed. And in fact, there is a provision for relaxation, my lord, with that which your lordship will get at page number 31. Regulation 49.
49,
Yes.
yes.
Where the board is satisfied that the operation of any condition under this regulation causes undue hardship in a particular case, the board may order to dispense with or relax the requirement of that regulation to such an extent and subject to such condition as the board may consider fit and proper for dealing with the case in a just and equitable manner by board. resolution.
Understood, sir. So the board has a power.
Yes.
Now, while passing the order at page 116, there is that
Yes.
relaxation
No, my lord.
specifically.
There my submission is, my lord, the Honorable Supreme Court, relying on 2-3 judgment, my lord.
This is
When
the
an-
fact that there is no relaxation,
No, there is relaxation, but that will be,
express relaxation.
no, there is no express, but it has to be inferred in this circumstance. Why I'm saying so, my lord? Apart from the cases of G.S. Lamba, Narinder Mohan and all, my lord, in my lord, this judgment,
Where is that board meeting resolution, 9/12/19, is it on record?
which one, my lord?
9/12/19,
Yes, yes, that is
Where is
at
it?
my lord, page number 103.
#103. Let us see where is this resolution to upgrade them?
Please come to page 104, my lord.
Hmm.
Agenda item number 3. Proposal for upgradation of the following post. Assistant Executive Engineer to the post of Executive Engineer, Assistant Executive Scientist to the post of Executive Environmental Scientist, and Assistant Engineer to the post of Assistant Executive Engineer. The chairman had informed the board members that most of the officers has completed more than 25 years of service in PCB. And since there is a less number of vacant promotional posts, the board may upgrade the post to boost up the morale of the employee. The member secretary also stated that upgradation may be done as per the following manner.
Hmm.
Now, if
Yeah,
your
but-
lordship should kindly come to see, my lord, we are concerned with this. From assistant engineer to assistant executive engineer, 10 years of minimum total service as assistant engineer in the board. After thorough deliberation, 13 number of assistant executive engineer may be upgraded to executive engineer. 2 number of assistant executive engineer scientists may be upgraded to executive environmental scientist, and 5 number of assistant engineer may be upgraded to the assistant executive engineer, keeping cadre strength at 264 number as revised on 213-14. This upgraded post will automatically come to the original cadre upon retirement, termination, resignation of the above mentioned post. The board member has agreed to upgrade this post under so and so 4.3, my lord, of the regulation. However, an intimation may be sent to the government. So they have invoked this power also, my lord, 4.3.
Yes.
The member secretary informed the board members that the financial involvement for upgradation of this post is approximately rupees 60 to 70,000 per month, and this amount can be borne by the board from the interest accrued without having any additional burden to the state government. Financial expenditure involved shall be borne by the students. So there was decision, my lord. Now, my lord, it is not that, my lord, any undue favor was shown to a particular or a particular class of employee. A policy, conscious policy decision was taken, pursuant to which it was taken. It's true, my lord. It is never our case that upgradation and promotion can be, equated. It all depends upon in what, if it is in administrative exigency,
Yes.
then certainly in my humble submission, my lord, the benefit would percolate. Now, therefore, once I reach the cadre of assistant engineer, my lord, yes, assistant engineer, then either by upgradation or by promotion, it is the prerogative of the board. Yes, if it can be shown that there any arbitrariness has, crept in the decision-making process, if unequals have been treated as equal, if equals were not given due opportunity, that's a different issue. Merely because we did not have, my lord, D degree, therefore, my lord, we cannot be considered, that cannot be the ground, my lord. And more so, my lord, our upgradation as assistant engineer were never put to challenge at any point of time. Not only, my lord, we are upgraded, we are also encadered in the sense, my lord, we are given equal pay as the assistant engineer. In my humble submission, in that view of the matter, my lord, the learned single judge's decision is too harsh, my lord. The nitty-gritty of the, circumstances were not duly appreciated, my lord. Prima facie, it appears to be so, my lord. But my lord, when you go a little deeper into the matter, then what follows is, my lord, perhaps the action is something which can be sustained. My lord, in service law, it's very difficult to apply any straitjacket formula in all the cases. It all depends upon how a service is framed form, my lord. All are the person who are manning the services, whether there are adequate number of persons are there, whether adequately qualified persons are there. So these are different aspects are there.
All right. Yes.
So therefore, my lord, my humble submission is now, if your lordship would kindly come to the impugned judgment of the learned single judge, my lord, which starts at page number 253. I'll have your lordship's kind attention to page 274 onwards, my lord. Now, at para 27, these are the issues which were framed by the learned single judge, my lord. Upon hearing the learned counsel for the parties, as well as upon perusal of the materials of record, the question which arises for consideration are as follows. Whether the 14 officers were upgraded to the post of assistant engineer by order dated 30/12/2005 was a mere upgradation simpliciter or could be termed to be a promotion. In fact, my lord, this limb of challenge was belated by 16 years. Whether in terms of column 9 of serial number 5 of table 2 in appendix 2, the term existing promotee engineer would include respondents number so-and-so, that is the appellant before lordship. Whether promotion of so-and-so by order dated so-and-so and so-and-so, as well as upgradation of respondents 13, 14, 15, 16, 17 to the rank of assistant engineer by order are required to be interfered. So, my lord, my lord may kindly come to page number 279. From the para 29. From the above noted paragraphs, it would be seen that in the case of Bharat Sansar Nigam Limited, the Supreme Court detailed out the various principles relating to promotion and upgradation. Among the 6 principles, it is evident, it is relevant to take note of that when there is an advancement to the higher pay scale without change of post, it may be referred to as an upgradation or promotion to a higher pay scale. It was also observed that there is still a difference between the two, in as much as where advancement to a higher pay scale without change of post is available to everyone who satisfies the eligibility conditions without undergoing any process of selection, it would be a case of upgradation. However, if advancement to a higher pay scale without change of the post as a result of some process which has the element of selection, then it would be a promotion to a higher pay scale. The principle has set out in the clause 3 of paragraph 29 in the judgment rendered in so-and-so, which is directly applicable to the facts of the instant case, taking into account the specific stand taken by the respondent board, wherein it has been stated that upgradation given to 14 officers while office order was without carrying out any selection process. This aspect of the matter has also been admitted in the affidavit filed by respondents, particularly in paragraph 7 and 8, wherein they categorically mention that the post of junior engineer were later rechristened as assistant engineer. Under such circumstances, this court answers the first question for consideration to the effect that 14 officers, including respondents so-and-so, were merely upgraded to the post of assistant engineer, and as such, there was no element of selection in this said exercise. The next question arises as to whether private respondents herein can claim the benefit in terms of the remarks mentioned in column 9 of serial number 5 of table 2 in appendix 2, in as much as it has been mentioned that for existing promotee engineers, the qualifications shall be relaxed to diploma in engineering. The learned counsel appearing on behalf of the petitioner has drawn the attention of the court to regulation number 9(2)D and submitted that there shall be a common cadre list of engineers of the board recruited as assistant engineer, either by direct recruitment or by promotion from junior engineer level before commencement of the regulation of 2012. He therefore submitted that promoting engineers as mentioned in remark column in reference to those engineers were to be promoted from junior engineer in terms of regulation 9(2)D. He further submitted that as the regulation is clear to apply only to promoting engineers and sans any challenge made to the said regulation, question of this code reading promoting engineers to include upgraded engineers do not arise. At this stage, this code also finds it relevant to take into consideration the submission made by Learned Counsel for the private respondent that it is a policy decision taken by the board to read the upgraded engineers as promoting engineers, and as such, this court under Article 226 of the Constitution should not interfere with the said policy decision. As already mentioned herein above, the Learned Counsel for the private respondents have also relied upon the decision of this court rendered in Dilip Kumar Garg. This court finds it relevant to first take into account the judgment of the Supreme Court rendered in so and so. It appears from the facts involved in the said judgment that initially diploma as well as degree engineers were treated differently in terms of UP Service Engineers Rules 1936. But however, by Rule 5(2) of the UP Public Works Department Group B Engineering Service Rule, both diploma and degree engineers have been treated at par. It is under such circumstances, Rule 5(2) of the rule was put to challenge. It is in that regard, Supreme Court observed that it is the administrative authorities who are in the best position to decide the requisite qualification for promotion from junior engineer to assistant engineer, as it is not for the court to sit over the decision like a court of appeal. It was also observed that administrative authorities have experience in administration, and the court must respect this and should not interfere readily with administrative decision. Further to that, it was observed that decision to treat all junior engineers, whether degree or diploma holders, as equal for the purpose of promotion is a policy, and it is well settled that court should not ordinarily enter into the policy decision unless there is a clear violation of some constitutional provision or the statute. It is under such circumstances the challenge to validity of so-and-so was turned down. Judgment in the opinion of this court does not apply to the facts of the instant case. First, there is no challenge to column 9 of the serial 5 of table number 2, which categorically mandates that relaxation shall be only available to existing promoting engineers. Secondly, in the case before the Supreme Court, there was a challenge made therein to the enactment of rules so-and-so for treating the degree holders and diploma holders apart. However, in the instant case, the authority making regulation have not treated the promoting engineers with upgraded engineers at par, and under such circumstance, the judgment is not applicable. More so, if this court accepts the contention of the private respondent, it would amount to legislating by this court, which would not be permissible. It is also relevant to mention that when statute of the rule mandates a thing to be done in a particular manner, by way of a policy decision of administrative authorities, a contrary course of action is not permissible. It would be within the authority to take appropriate steps for amendment of the regulation as per permissible mode or stick to the mandate of the regulation. This court is therefore of the opinion that in view of Rule 9(2)D, which categorically mandates that promotion from junior engineer level to the cadre of assistant engineer, reference to the remark in column 9 of serial number 5 of table number 2 in appendix 2 has to be in reference to those junior engineers who were promoted and not to those junior engineers who were upgraded, that too without any selection process. The third question for consideration is as to whether the impugn orders dated whereby respondent number 7, 8, 9, and 10 and 11 were promoted to the post of assistant executive engineer, and as to whether impugn order dated so and so whereby respondent 7 to 21 were upgraded to the post of assistant executive engineer were required to be interfered with. The promotion of respondent 7 to 11 and upgradation of respondent 13 to 17 could not have been made in their favor on the ground that they did not have the requisite qualification, that is so and so, in terms with regulation so and also do not provide any relaxation in favor of the said respondent. Furthermore, with respect to the respondent 13 to 17, it is not known on what basis respondent board has upgraded the officers by the impugn order dated so and so, which was rehearsed the provisions of Rule 7A1, which mandates recruitment to various posts can be made by of a direct recruitment or by promotion or by deputation or on compassionate ground or by way of a contract. Regulation 4.3 only empowers the board for the purpose of upgrading or downgrading a post within the sanctioned strength. However, with the approval of the government, there can be an addition to the existing strength of the cadre. However, the power under 4.3 of the regulation does not empower board to upgrade or downgrade the service of an officer from the post of assistant engineer to the post of assistant executive engineer, as that would be in violation of Regulation 7. For the reasons above mentioned, this court is of the opinion that promotion orders dated so and so and upgradation order dated so and so are in violation of the regulation of 2020, as they do not have the requisite qualification for the said and for which the said orders are liable to be interfered with. So this view has been taken by. My lord, my humble submission is it is, my lord, it was not appropriate or rather proper for the learned single judge to decide the manner in this fashion. My lord. The issue was, first of all, my lord, learned single judge should have given some meaning to the upgradation which was given to us in the year 2005 and which was never challenged until after 16 years. Yes, first.
So that first upgradation, even if we forget for a moment, question comes that under these regulations of 2012, whether there is any further power of upgradation given.
Upgradation, yes, expressly it is not there.
It's
My
not
lord,
there. So that what
no.
part of the order goes?
No, my lord,
The order whereby.
upgradation
goes-
part.
Upgradation part that
Yes,
goes automatically.
Yes, no, my lord, if your lordship will kindly come to
Method of recruitment,
4.3, my lord,
4.3.
at page number 3.
Yes. Yes.
This power was invoked, my lord, on that resolution. The board by resolution may upgrade or downgrade within the sanctioned trade. However, any addition to the,
This is for the purpose of adding or reducing the number of posts,
no, my lord,
not
With all the-
upgradation.
with all respect, my lord, no, normally
This
there
is
is, a-
cadre, the very header reads cadre.
yes,
It's not a mode of recruitment. This is cadre strength. They may upgrade or downgrade cadre strength. So many posts of executive engineer are downgraded to assistant engineer. That is what the power is. Not upgrading
whether
a person
power
from
to
one post.
upgrade an incumbent from
Yes,
one. Yes.
precisely. That is not the power.
Anyway, my lord, that is an area which I will respectfully submit. That's an area which is open for debate.
So one part is not even open for debate. One part goes specifically, and the other part is
Promotion.
qualification.
Yes.
There is no relaxation as such. So without relaxation, assuming that you are in the category of,
No, possibly,
for a
my lord,
moment,
possibly what transpired with the board was, my lord, since we are upgraded, therefore we are assistant engineer. Since we are assistant engineer, we are assistant engineer for all intents
all
and
practical
purposes.
purposes. Yes,
Because
that is,
equity knows no halfways, my lord.
that
If
is
I'm
one,
assistant engineer, then I'm for all purpose.
that is one permissible argument. We
Yes.
feel that is right.
So lordship may like to examine the matter, my lord. It's not a matter which can be disposed of at the admission.
You're right.
Lot many, I mean, views are to be given, my lord. There are decisions both
But then-
favoring against.
Then there is no case for stay.
No, there is interim order, my lord.
There already
Yes.
is.
There are two issues.
There is interim order.
Let's
Not being complied.
এটা কথা।
just hold on. What is the interim order?
My lord will have that IA number 925, both my lord will find it.
IA 925.
IA 9.
আমাকে একটা interim order দিছে তো?
That is 23/123 order.
তুমি কি আমি continue
Yes.
করবো দিছে?
The first order,
Yes.
therein, my lord, the second paragraph from bottom. In the meantime, so and so may be allowed to hold the post of assistant executive engineer till the process of fresh promotion to the post of assistant executive engineer completed by
I need
the.
to do
So in
90.
effect, the order has been directed to be, if there's a direction to comply with the order of the learned
Comply
single.
with
No,
the order.
the-
As an interim arrangement, they are permitted to hold the post.
Hold the post.
Yes.
Yes.
Then, my lord, they
There is
come up with a.
subsequent order is there, my lord.
They come up
Page
with a-
83.
Come up with another IA, that is 242, and the prayer made therein was.
Page 283, 83 niki?
No, 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 it was-
82.
And my lord will come to page 29 of that IA, not my, the present IA.
আর কোনটো আই এটা এইটো না 242 নেকি 242
My lord, after this order on 23/1/23 was filed, was passed, the appellants, my lord, then filed an IA 242/23. And wherein, my lord, the prayer was that they wanted a modification of 23/1/23 to the extent that the selection process should go on, allowing the present applicants to participate in the said selection process, but the result of the DPC should not be published without leave of this. Now, in terms thereof, this honorable court, my lord, passes an order which my lord would find at page 55 of that IA.
Order.
925 IA, order dated 3/2/20.
Yes, we are having that order.
Lordship. Here, my lord, after discussion of the things, I then, my lord, page 56.
So if the writ petition, there was a direction to consider the case of the writ petitioner for promotion to the post of assistant engineer.
That was not done, one. Then the whole promotion as directed by the honorable single judge was directed to be taken forward. DPC was not convened. Now they find this page 56, my lord, para 4.
Page
Subpara
56 of
The IM, that order dated 3/2.
that we are having in our hand. Yes,
Lordship will have para 4 there.
yes.
The second paragraph, subpara to para 4.
2 vacancies are available.
The available, Mr. Nair, so and so,
Ah.
there would be no difficulty of the part of the to consider the case of the present respondent for during pendency of this. Now, we are of the view that in the interim, since the respondent number 7 to 11 and 30 to 17, the petition are still holding the post of so and so, they may be allowed to hold the same. Now, my lord would say, fine. We also make it clear that all these appointments and arrangements made in terms of this order by this court today, as well as on 23/1/23, that is the earlier order, will be subject to final outcome of it.
Of course,
Now, the respondent authorities have done nothing.
they are sitting tight.
They are sitting. Because
Who is
they
for the
work-
board?
They have got their work done. These people have been protected. They are
তাহলে আই না
Yes.
So what had happened after the order of the honorable single judge? All these promotions were interfered with. Then in terms of the earlier order of this honorable court, they were continued.
And let's decide the appeal finally.
Yes.
Come on, 8th, 9th,
Ninth one.
come on 9th. All right,
9 to কি বলে
yes.
9:30 মানে
And Mr. Chaudhary,
my lord
the writing is on the wall so far as one set of your clients is concerned. Those who are upgraded, there is no power. So they virtually face the music. The other set, there may be a view that there is a deemed relaxation. There may be a possible view, but then these people will also be saved in that event.
no
But upgradation,
but my lord will also consider the belated approach after 16 years.
forget about that.
No, my lord.
Not challenge that. my lord, to
No.
They are not
No, my lord.
challenging that.
Our upgradation is never challenged.
Your upgradation in 2020 is definitely under challenge.
2005. No.
2020.
2020.
To
my
that
lord,
part,
I
yes.
quite
So
see the
the
fate of
promotion to a assistant executive engineer is by virtue of 2020 only.
Yes.
By an indirect means of upgradation. That's
And my lord,
2005
I have already submitted. That's an area where Lordship would like to.
2005, it's an upgradation.
9.
Then my lord, the rules does not permit such.
an upgraded engineer to promotion.
Instead of,
But the argument would be that he is virtually now and in the cadre.
yes.
So that upgradation effect makes him an encadred post.
Yes.
My lord, I'll place a judgment of it.
We'll see that, of course.
My lord, instead of 9, put it on 12th or 13th.
12th,
my lord.
12th.
No problem.
Not an issue. In the meantime, what is the stand of the board? Why have you not complied with the order?
We have to convene a election committee on 8th.
8th of May? Is it your statement?
Not my statement or official communication. has-
All right, then council representing the students board submits that the meeting of the selection committee or the DPC selection committee is being convened on 8th of May 2023 so as to ensure compliance of the directions given by this court. Full stop. The proceedings of the selection committee shall be completed expeditiously. The result thereof shall be placed for the perusal of the court on the next date. List on
Degree.
16th May.
My lord, there is one problem, my lord. If tomorrow Lordship holds that upgradation and diploma holders.
You can't prejudge.
No, what I'm saying is, my lord, let them proceed with the everything. They will not declare the result until further orders to be passed by
In
the.
sealed in sealed cover.
Yes,
Result in sealed cover.
yes.
The writ petitioner has to be promoted, sir. There's no doubt about that.
No, but as far as upgradation part is concerned, my lord, there is an, as I have, Lordship has already indicated, even we make submissions.
Oh, yes.
Lordship passes orders.
16th. Presumably as per law.
Item number 22.
Yes. Hmm.
Wait, please, Your Honor. The pleading is complete in this case, my lord. The writ appeal is against the judgment passed by petition, my lord. Judgment passed by the Central Administrative Tribunal, Guwahati, my lord. There was an allegation of sexual harassment against the petitioner, my lord.
Yes.
There was an inquiry held, my lord, and pursuant to the inquiry report, the impugned order was passed recommending removal from service.
Mhm.
That was under challenge before the tribunal. Tribunal has rejected the petition, and that's why, my lord, it has been filed, my lord.
Yes.
Now, our basic contention is that, my lord, in the entire process, my lord, there were fundamental irregularities in coming to the finding, my lord. Our chief contention is that, my lord, the act and the rule came into being on 9th of December 2013. The date of occurrence which has been alleged, my lord, that is on 3rd of February 2014. And the complaint was filed on 27th of June 2014, my lord. So the first contention is that, my lord, the act having come into being, my lord, the Vishakha guidelines were no more applicable. The Act-
Did the act exclude the operation of the guidelines expressly?
yes, my lord. The judgment itself says that this will hold the field till an enactment comes, my lord.
Okay.
In the ultimate paragraph, I'll place the judgment, my lord.
Yes, yes.
So first thing is that now what prejudice we have suffered, they have not followed the act. But first thing is that the complaint is barred by time, my lord.
Hmm.
There's a time limit of 3 months. 90 days has been given under section 9 of the act, my lord.
Hmm.
This complaint has been filed after that period. There is a provision for extension of time, but that has also not been done.
Hmm.
Number 2, my lord, after the inquiry report has been submitted, my lord, we get an opportunity to file an appeal before the appellate authority. Before the time was exhausted, my lord, the impugned order has been passed. Before 3 months was exhausted, my lord.
Appeal against what order?
Against the inquiry report, my lord. ICC has
Against
filed-
the inquiry
my
report.
lord.
All right.
That is 18, my lord.
So there's 3 months' time. How has the tribunal dealt with this argument? Let us see.
My lord.
How did the tribunal deal with this argument?
Tribunal did not consider all these things, my lord.
Read, please.
Tribunal's order, your lordship will find 159, my lord.
Yes.
One? 168 is the delay part, my lord.
168. Read, please. Hmm.
Paragraph 9, no, it's 167, lordship may read, my lord. We have
Yes.
carefully gone through the submission made by both the parties and the arguments thereof. It is observed from the submission of the applicant that apart from denying the charges allegation, most of the points relate to the procedural aspect.
Hmm.
Applicant condition is that committee should have been presided over by a woman. But there is also a provision that in case a senior level woman employee is not available, the presiding officer shall be nominated by other.
Where is that right of appeal? Where is it provided?
Well,
You
that has
said
not been
the appeal
considered.
against inquiry report.
Judgment,
Where
has
is
not
that
been-
argument?
My lord, my argument.
Yes. There's no such argument before the tribunal. The
That-
right to appeal was frustrated.
165, my lord.
Read.
limitation was argued, my lord. And the documents were not furnished.
Read, sir, read.
That is not there in the.
That is not there. So
Delay was argued and that, my lord, no document. There were 37 documents.
we'll admit your petition and we'll hear you at
My lord.
ease. What do you say, sir? We'll admit the petition, we'll hear it when the turn comes. The respondents are duly represented, pleadings are complete. The petition is thus, writ petition which is pending for admission since the year 2019 is thus admitted. Since the respondents are represented, notice need not be issued. List for hearing in due course.
Interim order passed earlier. my lord.
Interim order against what?
Against the-
Oh, then no, sir, then no.
No, otherwise.
What is the interim order?
My lord, the interim order, Lordship may kindly see.
Against termination?
Yes, no, my lord. No
Then-
termination, my lord.
Then
It was on, no, my lord, only removal was proposed. It was proposed. and
oh,
there was
then
a
you have
stay
to
in the-
argue it finally, sir.
Lordship,
No, no.
kindly see the interim order, my lord, on what consideration it was passed, my lord. What is the interim order, please? My lord, 4/5/2019, it says that, my lord, it was initially stayed by the tribunal till the end of the judgment. Therefore, this was continued, my lord. There's only proposal for dismissal, my lord. Since I had.
Finding,
Hmm?
that is after finding, this proposal was given.
I'm continuing under suspension, my lord.
Appeal also for that.
I'm continuing under suspension, my lord.
Because of the virtue of the order for of the court.
Yes, yes,
You are continuing under suspension.
suspension, my lord.
Why you are unnecessarily paying him 3/4 of the salary without using him?
Getting more than 1 lakh rupees salary.
Then without using his services.
That is the problem.
But you did not move any application for vacating the stay.
That we thought that it should be taken up as early as possible, because they take.
Since
some time
2019,
to
this is,
pass the notice to the other person. So many notices are have to waive up. They did not issue even.
Even the punishment of removal, Lordship, kindly see in the rules, possible punishments are given, my lord. And possible punishments are, my lord, censure, warning. increment.
removal is not a punishment.
Finally, one termination is there, my lord.
Service is there.
One is there, my lord. Here, considering the facts and situation, my lord. That is also a thing, my lord.
What fact situation? What fact situation do you contemplate that it would not result into termination?
That I may not submit, my lord. Lordship, kindly- It was not that grievous, my lord.
What was the allegation?
Allegation that I touched her hand, my lord.
That's what we say.
Another criminal case is pending. He wanted to deputy, assault the deputy commissioner.
That's a
Well,
different
that-
thing. That's not the issue in this writ petition. But in this case, the allegation, what we find is touching of the hand. To
is
that
the-
extent, it would be going
He
through.
apologized for that.
Yes, all right.
I'm sorry.
So-
I may be. Excused
So,
for this.
but
In a
touch-
committee matter. Take
touching
it.
of the hand, sir.
So that is what he has admitted.
Here it's too hot. Admit. List for hearing in the month, last week of June.
My lord, regarding interim order, that will continue, my lord.
The interim order read so and so shall continue till disposal of the writ petition.
Problem.
Letter number 23 to 29.
These appeals were filed by the revenue, challenging the order dated 20/2020. But after receipt of the notice, opposite party appeared, they challenged the maintainability of the appeal on the ground that this appeal will lie before the Honorable Supreme Court. Lord.
Mhm.
That is, Lordship is to decide. I have also filed my reply to their affidavit also.
Appeal to the Supreme Court
Lordship. under
on the
section
ground.
35L. Lordship may come to 35G. There is a exclusion,
Central Excise Act.
Central Excise Act 19.
Central Excise Act.
Part of the affidavit in opposition is, I not, the provision is forming part of the affidavit in opposition.
Just
35G.
yes.
35G1, an appeal shall lie to the High Court from every order passed in appeal by the appellate tribunal on or after first day of July 2003, not being an order relating among other things, or the determination of any question having a relation to the rate of the duty of excise or the value of the goods for the purpose of assessment. If the High Court is satisfied, so Lordship, they are.
But this is repealed.
Lordship. No,
This
Lordship, it was because by after the it was revived, Lordship, by the Supreme Court.
It was
in the
revived.
In the, yes, Lordship, in the judgment of Madras Bar Association.
Right, right.
Lord.
Hmm.
Now, Lordship, contention of the respondent is that because there is a question of determination of excise duty and value of the good, to appeal like to the Supreme Court.
Appeal shall lie to the High Court from every order passed in appeal by appellate tribunal. An order relating amongst other things to determination of question, rate of duty of excise.
Lord.
Hmm.
Here, Lordship, the question involved is that whether the respondent is liable to pay transportation charge under the Finance Act 1994 law.
Transportation charge,
Yes, Lord.
not excise duty.
No, Lordship, because it is under service. Let me complete, you will get your point. Lordship, I want to draw your Lordship attention to page 59 of my appeal law, paragraph 9.
Thirty,
Page 39, paragraph 9 is a part of the order of the Honorable Tribunal.
right.
Paragraph 9, in view of the above, it is our considered view that the transportation of crude oil has been undertaken by the appellant, SSC, in the capacity of being seller.
Not a service
not a
provider.
Service provider,
Hmm.
further, since there is no service provider, the service represent relationship, there cannot be any question of service tax levy. So, Lordship, there is no question involved with regard to fixation of any duty and other. So in my humble submission, appeal lies before this honorable court. And Lordship, under Finance Act, Lordship, the transportation of goods other than through pipeline is taxable under section 35-105 triple J law.
Mhm.
Section 65B
This is a transportation
of crude oil
by,
from the refinery to the
by what means?
through pipeline law.
Pipeline.
Lord.
And that as per you is taxable.
Is for the transportation charges and the taxable under section 65-105 triple J law.
Not being an order relating to, so this is, as per you, this has nothing to do with
Fixation of any
fixation of any rate of duty or
law.
value of goods for purpose of
Yes, sir.
assessment.
And Lordship, rate is also fixed under the Finance Act, Lordship, section 66 of the Finance Act 1994 law.
Mhm.
12% is the rate fixed as per the Act law. And under section 65-105 triple J, the service supply of the crude oil through pipeline is taxable law.
Yes, what do you say, sir? What's your argument?
Yes, sir.
Yes.
My lord, the question here is whether on this activity, service tax is liable to be discharged or not. That is
Hmm.
the question.
Hmm.
Taxability of this activity, whether it is liable to service tax. My lord, in section 35D and 35L of the Central Excise Act, my lord, these are talking about value of goods, etc., which are not applicable to service tax per se.
Mm.
What it says is, since it deals with central excise, it deals with goods. There it says that if it, 35D says, if it deals with any question about the value of the good or whether it is taxable or not, that will be determined. My lord, we come to 35L, page 36 of my affidavit in opposition.
35, well, yes, read, please.
Appeal to Supreme Court, my lord.
Mhm.
Page 36 of my affidavit in opposition.
No, we are having the act.
Yes, my lord.
Yes.
35L, 1, an appeal shall lie to the Supreme Court from a judgment of the High Court.
Yes.
B is applicable to us, my lord. Any order passed before the establishment of the national tax system by the appellate tribunal relating, among other things, to the determination of any question having a relation to the rate of duty of excise or the value of goods for the purpose of assessment, which is rate and value. explanation, my lord, for the subsection 2. For the purpose of this chapter, the determination of any question having relation to the rate of duty shall include determination of taxability or excisability of goods for the purpose of assessment. So whether the goods are taxable or not, that also falls under the purview of 35L. Case 39, my lord, is the Finance Act, which borrows these provisions for the purpose of service tax. Section 83, lordship have it.
Hmm.
The provisions, section 83, my lord, at page 39. The
Yes.
provisions of the following sections of the Central Excise Act, as enforced from time to time, shall apply so far as may be in relation to the service tax, as they apply to the relation to duty of excise.
Hmm.
So what they have said is the appeal provisions, 35L and 35C are borrowed for the purpose of service tax.
Hmm.
So taxability of service is the question which is borrowed by the Finance Act, my lord.
Hmm.
This question has been interpreted by various high courts, my lord,
Mhm.
where they have categorically said whether an activity is taxable or not. That is a question which falls under the purview of 35L. Therefore, the jurisdiction of the High Court is excluded under 35C.
Which
The very
judgment?
next page, my lord, page 40, is a decision by the Calcutta High Court, my lord.
Hmm.
The short judgment, my lord, I will speak for Lord convenience.
Hmm.
We have carefully examined 35C. I'm reading from the beginning of the judgment.
Yes.
As shown to us by T so and so. The provision has application to service tax appeals to High Court by virtue of section 83 of the Finance Act.
Mm.
This section very specifically states that the High Court shall not have any jurisdiction to determine any question relating to inter alia rate of duty.
Mm.
Paragraph. The respondent is engaged in the business of cleaning factory premises. According to them, they are not accessible to service tax for rendering the service, whereas according to the revenue, they are. The tribunal has held in favor of the respondent. Therefore, the question is whether the respondent is accessible to 0% service tax or 12% service tax. For those reasons, we allow this application, holding that the appellant has been able to show sufficient cause and direct the department to register the.
So there was a demand of service tax against which the appeal was preferred
Yes,
to this estate,
yes.
to the,
Before the High Court,
If-
said that the.
no,
Yes,
the judgment here, which is under challenge.
Yes.
The respondent filed the appeal against the demand of service tax.
Yes, ma'am. Yes,
Mr.
ma'am.
Kale, then what is the,
This has been followed in several judgments of the next page. My lord.
the plain language of 35L? Better it is withdraw and go to Supreme Court. Otherwise, you will face the issue of limitation also.
That will be because it was filed in 2021, Lord.
Yes.
Then it is pending.
Hmm. Read 35L, Mr. Kale. What,
I've gone through, Lord.
and after 35L, what remains? 35G excludes and 35L
Yes, Lord. If I,
gives you the right to file an appeal before Supreme. And the subject matter which of both the provisions, that is clearly made out from the order itself. You raised the demand of service tax.
we demand.
They challenged it.
Lordship, may please to see their reply to the notice, Lordship.
Hmm.
Neither they file
What about that? We are not on the merits.
Lordship.
What was the issue before this estate?
They said-
Demand of service tax.
Yes, that was locally executing authority passed the order that was challenged before the CSET. And in paragraph 9,
Yes.
the finding of the tribunal that in our considered view, that the transportation crude oil has undertaken by the
So
appellant.
the finding may be wrong for what we may say, but then the challenge lies to the Supreme Court.
Lordship, my
The provision is very clear.
No, because the rate of tax is also fixed by the Finance Act 1994
Right.
and it is taxable. Lordship.
We-
Lordship,
we are not on the fact, on the aspect whether the order of the tribunal is justified or not. The
No,
issue
Lordship.
is what is the forum of appeal.
I'm, yes, Lordship, Lordship, that to decide that whether the High Court has power to intervene.
Yes, yes. Then,
My humble submission, Lordship, as provided in section 35G, with regard to fixing of taxability and others, Lordship, that in my humble submission, the question is not there because first, Lordship, under section 35B, 35, section 65 only.
value of goods for purpose of assessment. So You say that this is transportation charges, so it is
Not-
neither value of goods nor,
No, my contention, Lordship, because it is already provided by the Act 1994,
Hmm,
because the service is taxable. Lordship, please to see section 65-105, Lordship,
hmm,
what is safe.
yes. What do you say about these high court judgments?
Lordship,
They are directly on the issue.
in my humble opinion, they are not applicable in the present facts and circumstances. Like,
Why?
Lordship, because here, Lordship, in that case, Lordship, that was not determined, that is to be determined. But in case, in this present case, Lordship, 65-105 triple J, I'm reading, Lordship, to any
Of
person,
the Excise Act.
Finance Act 1990,
What you are reading?
section 105,
Hmm,
65-105
hmm,
triple J,
yes.
to any person by any other person in relation to transportation of goods other than water through pipeline or other conduit. So that is made serviceable since 2012. Lordship. And the rate is also fixed by section 60. 65.
Assuming we are not again and again, we are saying that, yes, you may have a right to charge tax. Assuming charge service tax.
Yes, Lordship.
But supposing you raised a demand that was challenged and the tribunal holds in the favor of the SSC,
Yes.
where does the appeal go?
My humble opinion, Lordship.
Read 35L and answer us. Give the answer. 35L. Read,
No,
please.
I haven't got to Lordship.
Read, please.
Lordship. Appeal to Supreme Court. An appeal
Yes.
shall lie to the Supreme Court. A. Any judgment of the High Court delivered in an appeal under section 35G or reference made under section 35G by the appellate tribunal before first day of July. Then 3, on
Hmm,
a reference made under section 35H.
hmm.
Then B, any order passed before the establishment of the National Tribunal by the appellate tribunal relating amongst other things to determination of any question having a relation to the rate.
The rate of duty of, so rate of service tax.
Yes, Lordship, yes, rate of.
So rate of service tax, whether it is zero or whether it is applicable or not, or if at all applicable, what would be the rate? This is clearly covered by this.
My,
To clarify, subsection two says taxability will also include.
Taxability,
here rate is already fixed by the.
taxability, subclause 2.
Yes. Two.
X. So
For any
2, how do you get out of
purpose
2?
of this chapter, determination of any question having relation to rate of duty shall include a determination.
Determination of taxability. That is what the precise issue is in this appeal. Determination of whether movement of goods in pipeline is subject to service tax. So determination of taxability.
That already decided by Supreme Court in some other judgments. That is, that point is.
It would be taxable. We are not bothered about it. We are not on that. But
Where
question
in-
is, what is the forum?
Where the appeal will lie.
So
Not see me pass the order because it is pending since.
then you
2014.
better you will have to approach the Supreme Court.
No, Lord, we have no option, but Lord, we grant liberty. And
We will do that.
not,
Yes, all right. We'll pass the order.
not. No, sir.
Yes, dispose.
Chapter numbers 30 to 32.
Lord, in
Yes.
this case, I am requested to appear on behalf of the state of Assam.
Hmm.
I have gone through the paper. Finance has filed detailed affidavit. It has come from the learned single judges bench. So an affidavit on behalf of the education department will be very relevant because to give the various phases and status of the employees. Lord.
Then Advocate General,
Can
Mr.
you give us 2 weeks time to file an affidavit.
Saike submits that though affidavit on behalf of the Finance Department has already been filed, but in view of the prevailing facts, affidavit is also required to be filed on behalf of the Education Department.
Lordship.
He prays for 2 weeks' time to do the needful. Time prayed for is allowed, list after 2 weeks.
Highly obvious.
This for final disposal after 4 weeks, Khadija.
And
He
also,
prays for 4 weeks.
one more thing.
Yes.
They have generally said that we belong to teachers, but they have not, there are 3 categories of teachers.
You
Yes.
file your affidavit, we'll hear you thereafter.
Lordship.
Right now, we are not going to manage. 4 weeks' time to do that.
All gazette teachers are here.
4 weeks, 4 weeks.
All right.
All right. Passed over matters ले लीजिए फिर hearing करेंगे शुरू.
Matter numbers 8 and 10, pass over matter.
Wait, please, your lordship. Lordship, I'm sorry, I'll have to pray for an adjournment. It seems senior counsel, Mr. Didas is still on legs.
All right. A request is made to adjourn the matter list up 2 weeks.
Obliged.
And 10 both? Okay.
Yes. Obliged.
Very good.
Matter number 9,
May I please, your lordship, my senior is still on legs. May we fix at 2 PM, lordship?
Not 2 PM, sir. 2 PM we'll start the hearing matters. A request is made to adjourn the matter list next week. Okay. That's it.
Obliged, lord.
Done? Only the criminal cases now, no other cases. You fix another date in those matters. You ask the councils and fix another date. This bunch which is there, 53, you fix a date after asking the councils.
50, the reservation matter, my lord, your lordship wanted, the urgency was that the judgment of the single judge was overruled through an OM. And now what the government of Assam is doing, they know that the matter is pending. All promotions have been affected. Already 25 officers are before lordship. The constitutional validity, the appeal which was filed, the person has already retired.
Mm.
Mr. Chaudhary appears for it. But the OM for lordship is in direct now violation of Jarnail Singh too.
We understand, sir, but presently we are in the midst of hearing those criminal matters.
Yes, my lord.
So you take a convenient date
My lord,
after
only
15th,
if I can, because of the urgency.
in the week commencing from 15th. By then, we hope to finish off these criminal matters.
My lord, only the problem is that, since I'll be on leave from the third week, can it be lordship on the next week?
Next week, we'll still require for this hearing of the criminal matters. Since we are already midst of those hearings, we'll not like to disturb that.
25th. Then lordship will fix it on the 23rd, lordship.
23rd May. Why don't they mention it in the cause list, part heard, those criminal appeals? They should mention it in the cause list. Part heard should come. Yes, Mr. Mazumdar, 23rd May.
Yes.
Okay. Mr. Azhar, we plan to start now or at 2? You can begin. No, we'll send them back, don't worry. His Chaudhary is not here. All right. So you just recapitulate till
Yes,
what
yes.
point we have
Yes,
heard
yes,
you
yes.
without opening the files.
yes. Numbers
Yes.
36 to 48.
Lord, on the last occasion, I submitted before your lordship the point that was the acquisition that is made
Mm,
to the effect that accused number 9, Malsa Kimi,
Mm.
collected money from accused number 1,
Mm.
Mr. Pajinder Hojai. There is no evidence to this. In order to create the evidence, accused number 10 was made
the approver,
approver,
right? And his statement is exculpatory in nature.
exculpatory in nature.
So you had
And,
cited some judgments to that
Yes,
effect.
my-
Yes.
I cited one exculpatory judgment, my lord, that is 2000, volume 5 SCC, page 440.
Mm,
That judgment rejects, my lord, the statement of accomplice because it is exculpatory.
totally exculpatory in nature,
nature.
yes.
Then I had also shown, my lord, that the acquisition is that such a large sum of money to the tune of more than 4 crores was converted through one tapan.
Right, and Tapan is
Tapan
not
is-
examined,
Is not examined,
right?
though he was arrested. It's in the evidence of
Mhm.
accomplice that he was arrested by Calcutta police in
But his
connection with this case.
Fate in
only.
this case is not known.
Yes, but then CIO, the chief investigating officer, he says, though I knew, but we didn't know anything.
All right.
So my submission on that was that if that he had come, he would have said that, no, these are all false.
Mhm.
Then, my lord, I placed the evidentiary value of the accomplice by placing section 113 of the Evidence Act
Mm.
and 14B of the Evidence Act.
Mm.
And on that, my lord, I placed two decisions before your lordship.
114,
My lord,
yes.
1969 3 SCC and 77 3 SCC, which clearly shows, my lord, that it is not safe
to base the conviction only on the evidence. of the
Uncorroborated
accomplice,
testimony
unless
of the.
corroborated on material points. Then the learned, my lord, the learned trial court, my lord, in paragraph 28 to 36 held that the accomplice has been corroborated
By
by-
three witnesses.
by few
Three
witnesses.
witnesses.
Now, out of those, my lord, 4 witnesses, PW 18, 58, 69, and 136 are the hotel employees who came before the trial court and said that only about that Fojinder Hojai stayed
Used to
with us.
come, used to come.
That's the only evidence. There is no corroboration on material point. Then, my lord, the learned trial court, my lord, further said that his evidence was supported by PW 52, who is an executive magistrate and who signed, my lord,
The
Exhibit
identification-
77 and exhibit 19,
Identification. memo.
identification memo at the police station. And the other two are DSP NIA, they were also there. You know.
Mm.
For
For that, you argued about 26 of the Evidence Act.
26 of the evidence act, it is hit by, and I have placed, my lord, Kartik Chakravarti, there's full bench decision of the High Court, my lord, paragraph 35. I submitted before your lordship.
Yes.
Now, then I submitted, my lord, that they have taken steps to implicate Mohit Hojai by stating that mobile number so-and-so, he is the subscriber user.
Mm.
He is the subscriber, but it was used by the accomplice.
Mm.
Accused number 10, Mr. George Lanthang. I had shown, my lord, exhibit 34, which is part of the CDR,
Mm.
that the subscriber ID is not Mohit Hojai, but someone else.
Mm.
Then I submitted, my lord, before your lordship.
No,
One
we
paragraph.
added something to that, that George Lamthang himself doesn't say
Yes.
that I was using that number.
Absolutely.
Mm.
And then, my lord, the entire call data record, CDR, was rejected being inadmissible because there was
65B
no
was not there.
certification under 65B.
Mm.
Now, thereafter, my lord, I came to the other accusation where they say that accused number 9 handed over dollar to accused number 8. And I submitted before your lordship, there is not an iota of evidence.
So that
Even the accomplice doesn't support it.
doesn't say so.
He says what Malsakimi did with the dollar, that is not
Yeah.
within my knowledge. And Malsakimi has denied. Then I placed, my lord, the last one I placed was exhibit 43. Exhibit 43 is a so-called declaration which they allege led to the recovery.
Mm.
And the learned trial court found that this was,
In relation to another case,
that is apparent on 43.
that is
only.
the document itself speaks,
Yes.
yes.
That, but my lord, what learned trial court says that this was recorded after recovery. That I had placed, I'll place
Mm.
today. And at this stage, your lordship asked me, show us the Caesar list. Then I placed search and recovery memo,
Mhm.
exhibit 250 before your lordship.
Yes, please.
And then I submitted that the investigate, first of all, the no case number. Then one HL Thanga is said to be the IO he signed as investigating officer. Which case he was investigating is not.
It's not known.
Then the owner of the house from where these arms were said to have recovered
Mm.
was also not examined, though he is a witness, Lal Rova. And there is another witness, my lord, John Thaga. He was also not
Not
examined.
examined.
And the
Punch
only
witness.
person, my lord, who was present there and who has been examined is Mr. Karmial, PW 56,
Mhm.
who said that he led the recovery.
Right.
Even the person who recorded exhibit 43 was,
He was not examined. Okay.
so the recovery itself is doubtful. So this one, and today I will start with exhibit 43, the
Okay,
remaining.
okay. So we'll resume at 2.
My lord.
Even though they are drawing minimum of pay scale, shall be afforded the allowances in accordance with the pay scale. Financial benefits shall accrue to the petitioners from the appellants. From the date the review petition was decided, that is 23rd January 2017. No, stenographer that week. Last में correction हो करके मौका फिर sign करा दीजिए. Yes. Adjourn it. Okay. Hearing, you need not call out each and every matter. Only those who are there, we need to take up. Others are not taken up matters. Yes. Where is Mr. Chaudhary? Okay, very well. Because he needs to be here in this matter now. All right, start.
May I please, your lordship? My lord, for your lordship convenience, we have made a paper book of relevant exhibits. Every time exhibit
That will be good. Evidence is already there with us.
evidence is there, except one, my lord, which I'll be referring, I'll be giving separately or
Okay.
from there once.
Yes. Now you are referring to exhibit. What would you be referring to, sir?
But the exhibits which are relevant, which I will be referring, all exhibits are there.
All right, yes.
I'll give a copy to my learned friend also for their convenience. The exhibit paper book, please. Yeah. My lord, I will place, my lord, I have placed it, but I'll take your lordships again through exhibit
At your own
43.
pace. 43.
That my lord will get at page 8. Page 8 of the exhibit compilation.
Yes, yes. Banlal Channa.
Wallah. This
Alias
is by Wallah
Fons.
Shana. This is disclosure statement said to have been, my lord, made under section 27 of the evidence law leading to recovery. I so and so voluntarily disclose in the presence of independent witness, namely Lal Roha. He is the owner of the house from where the arms were recovered. There is zoning Thanga.
What is the place of recording of this statement?
That is not clear.
Not
The
clear.
person who has recorded, I'll place his statement. He says, I cannot say where it was recorded.
Whereas this query is being made in reference to the fact that where did the independent witnesses come from?
Yes.
We have answered a reference in Rajasthan. There was one judgment of Supreme Court when there was a passing reference that 27 statements also should be recorded in presence of independent witnesses. So we answered the reference saying that no, this is not required. It's not the intention of the act, the code of the Evidence Act.
So that deal was struck. These will not go, of course. A deal was struck between DHBJ and John Mijo,
Mm.
alias so and so, to supply arms for use of DHBJ,
Mm.
an insurgent group active in NC Hills area. So these
Yes.
will not go under because this has got nothing to do with recovery. It came to my knowledge that one Thanga of Tahan, Myanmar, that a consignment of arms containing M16 assault rifles and other communication equipment have been dispatched by him meant for DHBJ group. This also will not go in evidence according to my committee. The said consignment was kept concealed in the house taken on rent by one lady Nampuya.
Mm.
I can identify the said house in Torang village. And lead the discovery of the said consignment. I'm giving this disclosure voluntary without any pressure. Now, my lord, the arms and communication equipment was supplied by someone and
This
He-
document is recorded on 30th September
it's a 30th.
2009.
30th July.
July, okay.
July. It will be 30th July.
Yes, 30th
It's
July.
recorded by PW 14. I'll place his statement
Alright.
also. And
This
there
is
is
about 4 months after the registration of the FIR
my lord.
pertaining to recovery of cash
Yes.
and the arms. Yes.
So a bare perusal of this exhibit 43 would reveal
Hmm.
that the person who is making this statement,
Hmm.
namely accused number 8, is not author of the concealment. My lord is well aware, author of a concealment. It should be
27 does not necessarily mean that the maker of the statement must be the author, even if he has knowledge.
My lord, author of the concealment, what I mean is the person
Is the-
who has exclusive knowledge. Now, suppose, my lord, a dagger
Hmm.
is used for killing somebody and it is thrown at a public place. Now, somebody.
That's a different thing. We will give you another example.
My lord,
Now, supposing there are two accused, X and Y.
my lord.
X commits the murder and Y is the accomplice.
Yes.
After committing the murder, X and Y go together to a house. X conceals the weapon at a particular place.
Yes.
Y notices it.
Yes.
And X absconds.
Yes,
Now, Y's statement is recorded that I have seen X
yes,
concealing the dagger.
yes.
That will very much be a relevant fact.
It will be relevant.
So
that's
same
not-
thing, same
that-
way,
no.
he says that I know and I can lead to the discovery.
What he says that he has come to know, he has been informed by someone who has not been examined.
On the strength of this statement, all that can be inferred is that Vanlal Channa knows that a
That's
consignment of weapons is
That's all.
concealed in the house of so and so.
Yes, my lord, see, the example that I was giving to my lord is that a knife is thrown in a public place. Nobody has seen, one accused is arrested, he says that it was thrown at that place, it is recovered. Now the Supreme Court my lord says that he is not the author of concealment, means he is not the person who has concealed it. Author of concealment, I'll place from my lord, the Kotayas, the Kotaya lordship will know, Privy Council does the leading judgment even till date. Author of the concealment means he is the person who has exclusive knowledge of something which is varied, which will be relevant with the crime.
Right.
So my submission would be that 43, as your lordship has correctly said, that it is maybe in his knowledge that the weapon is kept in Namko's house.
Was the arrest memo of Vanlal Channa exhibited?
No.
In that case, wherein the statement is recorded?
No. No, there is no case except this. Because
So,
My-
then the other question would be whether this statement is made by an accused in custody.
that is again, my lord, I will say that the evidence on record creates doubt about his custody. I made a reference, passing
So that
reference.
is why we are asking you, is there any arrest memo on record
No arrest memo.
corresponding to
In
this?
the charge sheet, only it is mentioned.
What
Only
date of arrest is mentioned,
date of arrest is mentioned.
but memo was not
No
proved.
memo was not produced, not exhibited.
Very well. Carry on. sir.
Now, my lord, the first judgment on author of concealment is Kotaya. Your lordship will take up the compilation of the judgment,
Compilation of the.
judgment. The blue color. This is on, no?
No.
Oh. No, judgment. Blue position.
Evidence.
It's like this.
Judgment will differ. Brown color, mother.
No, this. Upper bound file,
Brown color. Brown color.
hard bound, soft bound file. It's here, no?
Yeah,
Evidence.
ডাঙৰ আছে লেখা।
These are all evidences. ये लिखा क्या लिखा है इस पे? So this must be it. This must be it. यही तो है. हाँ, this is it. Yes. You are reading, referring to?
My lord, I'm referring to page 75,
Pullukuri Kotaya.
my lord.
Yes.
The 1947 Privy Council, page 67, but I'm referring it from Manupatra, which I have annexed. If my lord will kindly come to page, paragraph 10, my lord.
Yes. Para 10.
My lord, paragraph 10. my lord. At page 79.
Yes.
Section 27, which is not artistically worded, provides an exception to prohibition imposed by preceding section and enables certain statements made by a person in police custody to be proved. The condition necessary to bring section into operation is that discovery of a fact in consequence of the information received from person accused of any offense in the custody of a police officer must be deposed, and thereupon so much information as it relates distinctly to the fact thereby discovered may be proved. That's why I was saying, he told me this, he told me that, those things will not work.
That has to be excluded.
excluded.
That has to be eschewed from
Right,
consideration.
right.
Yes.
The section seems to be based on view that if a fact is actually discovered in consonance of information given, some guarantee is afforded thereby that information was true. Accordingly, can be safely allowed to be given in evidence. But clearly, the extent of information admissible must depend on exact nature of the fact discovered to which such information is required to relate. Normally, the section is brought into operation when a person in police custody produces from some place of concealment some object such as dead body, a weapon, or ornament said to be connected with the crime of which informant is accused. Sri so-and-so for the Crown has argued that in such a case, fact discovered is the physical object produced, and that any information which relates distinctly to that object can be proved. Upon this view, information given by a person that the body produced is that of a person murdered by him, that the weapon produced is one used by him in commission of a murder, or that the ornament produced were stolen in dacoity would be admissible. If this be the effect of section 27, little substance would remain in the ban imposed by the two preceding sections on confession made to the police, that is 26 and 25, or by person in police custody. That ban was presumably inspired by the fear of legislature that a person under police influence might be induced to confess by exercise of undue pressure. If all that is required to lift the ban be the inclusion in the confession of information relating to an object subsequently produced, it seemed reasonable to suppose that the persuasive power of the police will prove equal to the occasion, and that in practice the ban would lose its effect. On normal principle of the construction, their lordships think that the proviso to section 26 added by 27 should not be held to nullify the substance of the section. In their lordship's view, it is fallacious to treat the fact discovered within the section as equivalent to the object produced. The fact discovered embarrasses the place from which the object is produced, and the knowledge of the accused as to this and information given must relate distinctly to this fact. Information as to past user or past history of the object produced is not related to its discovery in the setting in which it is discovered. Information supplied by the person in police custody in inverted comma it is mentioned, I will produce the knife concealed in the roof of my house does not lead to discovery of a knife. Knives were discovered many years ago. It leads to discovery of the fact that a knife is concealed in the house of informant to his knowledge, as my Lord Chief Justice had just said about 2 persons accomplice. And if the knife is proved to have been used in the commission of the offense, the fact is very relevant. But if to the statement, the words as it with which I stand, these words are inadmissible. Then-
You read these 5-6 lines, it's very confusing.
My Lord,
They say that the knives were discovered years ago,
yes,
but the fact discovered is still relevant. What fact was discovered? The house.
the fact discovered was the knife was recovered. A knife was recovered.
How
Whether
is
it
that
is
fact
used,
discovered on the information of the accused?
yes, but it is used or not, that's a difference.
No, sir. Question is, in these facts, when the knives were discovered years ago,
Yeah,
how is the fact of knife discovered attributable to the information supplied?
but that is
So
what
the-
it.
This judgment to our mind is not having much clarity.
My Lord,
They are trying to say that the fact that the knife was concealed in the house
Yes.
is probably relevant. That also would not be,
My Lord.
because what is discovered only is the house.
Yeah.
That doesn't lead to any inference.
Yeah.
Very well.
Now, one of the second question, maybe
So
this will
what
be,
you are arguing is, and regarding that proposition, I have my doubts,
Well-
is that you say that exclusive knowledge of concealment.
yes, yes. Because
That is what
otherwise, he will have the information from
No.
elsewhere,
No. Issue that again, I'm telling you
my Lord.
that what, in this case, supposing the weapons were concealed by this lady
And I come,
and he was a privy to it,
no, that is different. That has to be on the evidence. That's what I'm
So-
saying.
that would not, from this information, that otherwise also could not be recorded.
Yes.
That I also was a part of it.
No,
So what is discovered is that the fact that weapons are concealed in this house.
that much was in the knowledge.
But that's it.
That's all. So therefore,
So.
for the purpose of section 26,
mm,
I'm submitting before your lordship. And again, under the cost of
26
repetition,
argument, yes. that's a
at the
different
cost
thing.
of repetition, I'm submitting
Yes.
that the knowledge must be exclusive. That I will show from the decision. 2 more decisions I'll place before your lordship. My lord, kindly have the compilation, page 91. This is Rao Sahab Balu Kiledar. It's there at page 91.
Exclusive to the extent the IO should not be having prior knowledge of it.
Well,
That is what the judgment is. Yes.
I'll just, my lord. My lord, I'll place, my lord, your lordship got, my lord, page 91.
Mhm.
Paragraph 2, I'll place, my lord, 2, 3, and 4. The only evidence on the basis of which the appellant has been convicted for the offense under section 3, section 25 of the Arms Act 1959, is the recovery of a country-made revolver and cartridge pursuant to a disclosure statement made by the appellant under section 27 of the Evidence Act from place behind Kohinoor Mill, Bhadar. The disclosure statement exhibit 11 was sought to be proved by evidence of punch witnesses, that is PW1, 9 and PW12. According to the prosecution case, on 27/7/99 at about 1:30 PM, the appellant was in custody of the police. So NM Joshi Marg Police Station made a statement under section 27 of the Evidence Act in presence of so and so, which was reduced in writing, disclosing the place where the weapon, a revolver with live cartridges, have been concealed. The appellant thereafter led the police party to the place behind Kohinoor Wheel Bhadar and pointed out the place and himself removed the earth, and a pit about 6 inches deep recovered a revolver loaded with live cartridge, wrapped in a polythene bag. The trial court relied upon this evidence and came to the conclusion that the appellant was in conscious possession of the revolver and the cartridge and convicted and sentenced him as noticed above.
Mm.
We have gone through the judgment of the learned designated judge, the evidence of PW1, 9, PW12, and documents so and so, The trial court has extracted the admissible part of the statement of the appellant
Mm.
recorded under section 27 of the Evidence Act in paragraph 27 of the judgment. That statement has translated by the learned designated judge reads in
Rupam,
inverted comma.
That's
Revolver concealed,
AIR 79 Supreme Court matter. Nikalo.
revolver concealed. In the other, come on, I will point out the place and revolver. From this statement, we are at loss to understand how the trial judge could have come to a conclusion that recovery pursuant to it could clothe the appellant with conscious possession of revolver and cartridge. The statement extracted above is capable of an interpretation that the appellant had the knowledge about the
That's what,
concealment
that's
of.
what I,
Yes.
he might be
concealment-
having knowledge that the lady
Yes,
was having the weapons concealed in her house.
that's right.
Yes.
At a particular place from where it got recovered and not that he had concealed it. Not that
He had
concealed.
concealed the same. Yes.
In this view of the matter, it is not possible to say they conclusively prove that he was.
Okay.
Then, my lord, before I go to 1917, I wish your lordship has.
Halya Mutya will be.
No, my lord. Let me place, my lord,
Yes.
Godan.
Godan.
State of
Godan.
MP versus Godan. That is
Yes.
2003, 12 SCC.
Hmm.
Page 485.
Yes.
This is page 93 of the compilation. my lord.
Yes, please. Carry on, carry on. Yes. One nine four nine. Yes. Yes, please.
My lord. My lord, I'm getting impatient, so I'll come straight to paragraph 9.
Read, sir, read. Yes.
Page 97, then I'll go to the other.
Hmm.
Page 97. We have already noticed that the weapon allegedly used in the crime was recovered from the house of one Chandan. Your lordship, my lord.
Mhm.
One Chandan, who though examined did not support the prosecution case. The recovery, in fact, cannot be said to be from a place to which the respondent alone had exclusive access. The possibility that the said weapon being with the said child always cannot be ruled out. In fact,
Yes.
the factual background, much importance cannot be placed on the recovery of the weapon.
Right.
Then, my lord, on authorship of concealment, if your lordship can kindly see page 87 of the compilation on authorship of concealment.
Mm.
This is State of MP versus Jogeshwar, 83 2 SCC 305,
Mm.
page 87. I'm referring paragraph 6. my lord.
Mm.
Paragraph 6 is at page 89. The gun, exhibit 23, is alleged to have been recovered in pursuance of a statement made by accused Durga. The evidence of ballistic expert Tariq Alvi shows that empty shells which were found at the spot of the occurrence were fired from that gun. This would be very good evidence to connect the accused with a crime. The police did not recover the gun from Durga. Nor indeed did he make a statement that he has concealed it at a place which he would point out. The discovery under section 27 of the Evidence Act is not of guns or daggers used in the crime. Guns and daggers have an ancient origin and one doesn't have to hunt for an accused to discover them. The discovery mostly and really is as regards authorship of concealment. Conduct and concealment and incriminating circumstances, and their discovery becomes relevant and admissible under section 27 of the Evidence Act. Here we are left with the position that the guns were recovered from a person called Sudhir Ahir, and shells and cartridges found at the scene of offense were fired from that gun. Inexplicably, Sundar has not been examined in the case. His evidence could have shown what is alleged by the prosecution that Durga had borrowed his
Yes,
gun
over
about
there.
material
Give it-
crime.
Yes.
Sundar having not been a witness in this case, there is no legal evidence to connect Durga with the case. So what I was,
You perhaps would like to read para 15 of this judgment.
my lord,
Para 15.
my lord.
On your right, in the middle,
Uh,
15.
This is Bohala versus State of Maharashtra.
Ohalia Motia Valvi.
No. The High Court reads the statement as reproduced in its judgment. I give my true statement before Panchal that then comes in an admissible portion which you did not consider. That is spear I have hidden in grass in my field of Jawar to the southern side of my house. That is spear and ready to produce. The High Court used this used the pronoun I as at two places. We, with the assistance of both learned counsel, proficient in Marathi language, read the original statement. The reading of the statement by the High Court appears to be far-fetched. Even the High Court is conscious of it when it observed in paragraph 20 of the judgment that the authorship of the act of concealment of his prayer would be implied and would be none other than the appellant, and then observe that this circumstances, which is one of the strongest links, stand duly established. The Marathi word me is to be found at the commencement of the statement, followed by the wholly inadmissible portion. And then there is reference to the place where spear was hidden. Marathi expression so-and-so would more appropriate be translation has been kept and not I kept. So, there's no thing, this is better judgment rather, because in the case of have kept it, the Marathi word would have been so-and-so. It may be that being not conversant with the Marathi language, our translation may not be appropriate, but if the recovery of the bloodshed spear is the only important circumstances of incriminating character established in this case, and if the authorship of concealment is not clearly borne out by any cogent or incontrovertible evidence, but as the High Court observed, left to be inferred by implication, we have considerable hesitation in placing implicit reliance upon it, more so when it is a confession which becomes admissible under Section 27 of the Evidence Act, made immediate presence of the police officer. The discovery of bloodstained spear becomes incriminating not because of the recovery at the instance of the accused, but the element of criminality tending to connect the accused with the crime lies in the authorship of concealment, namely that the appellant who gave information leading to its discovery was the person who concealed it.
And next two lines are very important.
And in this case, Hamta was another co-accused. The appellant may have only knowledge, this is what your lordship is saying, knowledge of the place where it was hidden. To make such circumstances incriminating, it must be shown that appellant himself had concealed the blood-stained spear, which was the weapon of offense. And in this point, language used in contemporaneous record of Exhibit 28 is not free from doubt. When the two constructions are possible in criminal trial, one beneficial to the accused will have to be adopted. Therefore, this linchpin of prosecution case ceases to provide any incrimination. This is a better action. I should have put it. I missed it about. So, my lord, authorship of concealment means he has the knowledge. He is the
Yes,
person who
sir.
concealed it. That's what it is. Now, in my humble submission, my lord.
If it was to be treated as incriminating this accused,
Yes,
he should have been the person who had concealed.
yes,
Mere knowledge that the weapons are
he
concealed
would not.
is not sufficient.
That's exactly this what I, my lord, wanted to place
Yes.
before lordship. Now, my lord, I'll place PW 14 to show that he is the person who has written this.
PW
And
statements,
yes, his statement,
statement wala paper. We have it.
page
here.
29, page 29.
Yes.
Given us, yeah.
There's one more piece. Yes, we have it. Relevant evidences. Page 29. ये हटा दीजिए।
My
PW.
lord, first I will place the relevant one to make my point, and then I will place the whole thing
Yes,
if the lordship desires. My lord, at page 55,
Hmm.
if my lord will come to the
55.
I'm sorry, 31,
Yes.
page 31, my lord. My lord, this cross, I will refer 4 lines.
Yes.
Page 31, my lord. In the year 2009, my lord got it.
Hmm.
I was working in CID department. I'm not attached to IGL PS in 2009. I'm also not associated with IGL PS case number 238 of 2009, but in connection with which the 43, exhibit 43 is written. Your lordship will see the exhibit at
Hmm.
page 8. Your lordship will find on the top right-hand side, IGL PS case number 38. It may not be clear.
Hmm. Yes.
My lord, it may not be clear. My junior says it may not be clear because written by hand, but if your lordship can see exhibit volume 1. Or it has got, because we made photocopy of the photocopy. Exhibit volume 1.
Hmm.
That this is really important, my lord. Because the statement is made under some, recovery is being shown under some other case. Exhibit volume 1. Page number 79, my lord. Page number 79.
Yes. Isol PS case number 238 oblique 9.
209.
Yes.
Now, this PW says in that cross which I said.
Not associated with 238.
I'm not, I'm also not associated because he is in CID, my lord. Not associated with IGL PS case number so and so.
Hmm.
On 37, the date on which this statement was made, accused Vanlal Chana was in the custody of IGL PS. The exhibit 43 is written in my handwriting.
Hmm.
Then subsequently, your lordship will see, I did not file any petition before the court for recording the statement of Vanlal Chana. I have not shown the original case diary of IGL PS case number 238 of 2009. Unless I go through the original case diary,
Yes.
unless I go through the original case diary, IGL PS, I am not in a position to say exactly where the statement of exhibit 43 was recorded. And my lord, the IO of IGL PS case number 238, he doesn't say a word about this, either recovery or statement or seizure, nothing. He doesn't say.
Mhm.
Now,
Who is that IU? Can we read the statement right now?
yes, PW 13, 13, that is, PW 13 is not in your lordship, you just give the number.
Paperbook volume 1.
Prithvish Kumar Traki.
My lord, 13
No,
is
13
at
is-
page, your lordship has, yes. My junior says it is not there.
It's not there in this evidence.
Yes. We'll make it and we'll give separately, my lord.
Give it.
This is paperwork volume 1.
Hmm.
Lordship may come to page 51.
Hmm.
51.
Yes.
Now, both these statements were recorded on the same day. Same day, 28/5/2013.
Hmm.
I'm placing my lord. PW 13, Shri K. Lalni Thanga.
Hmm.
Since 1995, I have been working as sub-inspector of police, government of Mizoram. In the year 2009, I was working at Aizawl police station as sub-inspector of police. When I was in Aizawl police station, I took up the investigation of Aizawl PS case number 239 of 2009, dated 18/7/2009, under Arms Act. Accused Banlal Chana of Sarongveng Aizawl during further investigation. another person, there are two, it appears, Manlal Chana, who is temporarily living in Saragong. Aizol is also suspected to be involved in this case. He was then arrested. Now this is accused 8 who was arrested. The other one, too, we don't know. There is nothing on the record. He was then arrested in connection with the above case and forwarded to the Aizol court for police remand for 4 days. The prayer of the police remand is allowed by the court. During remand period, he was interrogated but could not find his actual involvement in connection with the Aizol PS case number so and so. He was then forwarded to the court praying to discharge him from the liability of the case. However, he is suspected to involve in NIA 1 of 2009, and the prayer was made in petition exhibit 41, which is certified photocopy of the petition. Exhibit 41(1) is my signature. On the basis of the learned magistrate passed an order and the certified copy of so and so. I have not seen.
What is this petition about? For taking
This
his custody?
petition is that he is not in this case, but during interrogation, he revealed.
So the application was to take his custody in the NIA case.
No,
But then
that nothing is there.
41, what is 41?
41 is, my lord, an application for discharging him from the
That is all.
from the case. That's all. I will place, my lord.
Okay.
Now, my lord, and 42 is the order of the magistrate. Now, my lord, he is an IO. He is producing the man and he's saying he's not involved. Whereas he is supposed to record 43 and recover the arms, my lord. He doesn't say anything about it, and he is producing this accused on 31. And this, my lord, exhibit 43 is recorded on 33 by a person who is no concern.
Who
has
is
no
the
concern.
officer from NIA who was present when this
Yes.
43 was recorded?
56.
56.
I'll come to his
Okay,
statement.
okay,
now. They're
we'll-
very interesting.
We'll go with your pace only.
Yes.
Yes.
Now, my lord, the person who records is a different, he has no connection with Aizol PS case number 38. And his subsequent statement, my lord, creates grave doubt about the arrest, although there is a judicial order. But still, my lord, with all respect, this creates a doubt on the very
Judicial order
arrest of
Police
accused eight,
custody remand,
my lord.
order of police custody.
No, all, my lord, I'm saying he was not even arrested because this is what PW 14 says.
Mm.
PW 14, I will place it,
Mm.
what he says. But first, I'll take your lordships through exhibit 41 and 42. My lord will.
Yes.
Now, exhibit 41 is at page 6, my lord. I hope it's clear.
Yes.
Otherwise, my lord, it is in volume 1, exhibit paper book at page 77, but we have, in fact, my lord, I asked my junior, you should have written from where it comes. Exhibit paper book, so and so, you should have written.
It's okay, no issue. Yes.
This is addressed to Chief Judicial Magistrate Aizol, District Mizoram. I beg to forward here with the below noted person who was arrested in connection with the above referred case and remanded him to police custody for the last 3 days. During his remand period, he was thoroughly interrogated and found no involvement in this case. So on his statement, they said that he is not involved. I therefore pray that he may kindly be discharged. Then he says, however, he is allegedly involved in NIA case number so and so, section so and so, so and so. Then your lordship will see, my lord, kindly see here, last 3 days he is staying in this application. The next page, exhibit 42, is the order by the learned magistrate, which says on expiry of 4 days of remand. So 4 days he was in police custody. Date of arrest is nowhere mentioned. On expiry of 4 days of remand, accused so and so of Sarangong Aizol is produced by the police before the court with a prayer submitted by the IO Shri K. Lalni Thanga of Aizol PS for discharging him from the liability of the instant case. Prayer is allowed. Let him be discharged from the liability of the instant case. This is the only order.
Mm.
There is not even a whisper about recovery. Because Aizawl PS case 238 of 2009, as it appears from 41, it was connection with the arms. And arms were recovered and he says he's not involved. Because
What effect does the discharge have? He was released or what?
No, subsequently, my lord, PW 56 says, I arrested him on 31.
On
Maybe
31.
before
Once he was arrested,
he was
the,
arrested. But my lord,
discharge.
what I little know is if he's arrested in connection with some other case, he should have filed an application that he is wanted in this case also. So either
because-
show him arrested in that case.
From what this order indicates, there is no direction under section 169.
Yes. Absolutely. Now, my lord, I'll come back to again why I'm saying it raises grave doubt about the arrest of accused number 8. Because of the evidence of PW 14 himself, the CID officer. Because
Yes.
all persons involved, my lords will remember, exhibit 250, that search and recovery, they are all officers are there from the CID.
CID.
No police from Aizawl.
Hmm.
My lord, exhibit 14, sorry, PW 14 is at page 53, no? 39. no?
Yes.
At page 54,
53 is
at page 30, my lord.
30, no?
Page 30, my lord.
Yes.
My lord, at the last line of the cross-examination,
Mm.
last line at page 30, we have gone for recovery of material exhibit. My lord, got it. The last line. At
Hmm.
page 30. We have found one lal chana. At page 30, my lord, cross-examination and that last line. The evidence, my lord, starts at page 29. Page 29.
Just. Yes.
And at page 30,
Mm.
the last line, if my lord will kindly.
When we have gone for recovering
Recovery
metal exhibits.
material exhibit, we have found one lal chana,
in the village Longmont.
Longmont.
So.
He was at large at that point of time.
Mm.
When we met Banlal Chana, he is nowhere connected with any case.
Ah.
This is what, my lord, creates doubt in my humble submission. Then
But there are two Vanlals as per you, what you said.
there
Which
are
one?
two, but my lord, it is for them to say who has made that exhibit 43 declaration and whom they arrested. Because that also.
Because this accused number 8 was in judicial, under orders of the court, he was in PC.
Yes, my lord.
Mm.
Now, it's very difficult, my lord, for us
Right,
to say who was there, who was not there.
right.
Then, my lord, the few more lines I try, your lordship can see. The building where from the material exhibits were recovered was under possession of whom is not known to me. Then again, he says the rented house from where material exhibits were recovered was under possession of one Nampui. Nampui has not been made an accused in connection with this case by NIA officers accompanying me, nor I have advised them for making her an accused, despite the fact that all these material exhibits have been recovered from rented house. So, my lord, very clear that weapons were recovered from the house of Nampui, who has not even been interrogated. I don't know why.
No, you know, Mr. Mishra,
My lord.
your defense cross-examination makes the things clear. They have made this distinction. There's one Vanlal Khem,
Yes.
for whom the cross-examination is there, that he was in custody of Aizawl PS.
Yes.
And when you refer to the cross above, that is for Vanlal Channa.
Now, one thing I will say, what we have said here, because Banlal Chana, the person who was arrested by NIA and who made this statement, who said to have made this statement, my lord, they say that passport was also recovered. And that passport doesn't have any alias. Otherwise, one Lal Chem, one Lal Chana, so many
Sir.
allies are there.
But you refer to one document where there are two Vanlals,
That's right. That was PW 13 statement,
PW 13.
PW 13 statement.
And even PW 14 says,
Yes.
you see that at the top of page 30, we
Right.
met Vanlal Channa who was at large,
Yes.
not connected with anything.
Any case.
And Vanlal Chem,
My
he
lord.
says he was in custody of Aizol.
And, my lord, my lord, who?
RH Khan Cross.
Yes, one Lal
Look
Chem,
here.
yes, one Lal Chem. Now, who? I am one Lal Chana.
That's what I'm saying.
what he
You
can
again
hear.
missed something.
Yes, I. Your lordship is absolutely correct. I'm grateful. my lord. And this is the third. I would say.
This I got, when you read PW 13, there were two Vanlals.
Yes,
So this confusion is there,
yes, my lord.
that which of the Vanlals was
Yes.
actually
In custody.
responsible for exhibit P43.
Yes.
Because if you see this cross examination,
Yes.
read this cross examination of RH Khan.
My lord. It is not a fact that I have written exhibit 43 is not given by Banlal Chem voluntarily. We did not prepare any seizure memo. While alleged seizure of an exhibit 11 and exhibit 14. In material exhibit 11 to 14, there doesn't appear any signature of mine or any person involved in the raid. He has not signed, my lord, I said, even he has not signed the exhibit 250. His signature doesn't appear. On that particular day, that is. 30
Chief, he says Vanlal Chem, Moentia, Vanlal Channa,
Yes,
they have all same aliases.
my lord, same alliance.
Same person, yes.
Yes. But then I will show, my lord, they have recovered the passport where it is only Banlal Chana. There is no alliance.
Passport would not contain the alias. It would never. Anyhow,
The other, even other things are also there too.
all right,
I'll
yeah,
place.
all right, all right. Now,
Now,
next.
therefore, my lord, what I'm submitting before your lordship is
Hmm.
that if Mr. PW 14 is to be believed, then accused number 8 was not in custody.
Not in.
Who was in custody was Banlal Chem or what?
Hmm.
Now, my lord, I will place the relevant portion of HS Karmial statement. That is 56 at page. I'll just give my lord where in your lordship's paper book. No, it is 9. My lord, this also is not there because that was filed during, I think, bail, admission or bail stage. So your lordship may take up paper book 2.
Yes.
My lord, whatever is not there, we will give it, can be again. And
No, we'll see from the original file. Yes,
My lord,
paper book.
paper book 2. Page number 418.
Yes. Hmm. Hmm.
My lord, the relevant portion which I would read, my lord, is at 420. 420.
Yes.
Now, 9th line from the bottom, my lord,
Hmm.
that page. On 37/2009. Accused Vantia Vanlal Chana voluntarily gave his disclosure to IO of Mizoram Police. This is not correct. IO has not taken, this is by PW 14 who says I have no connection with Aizol case 438.
Yes.
Gave his voluntarily gave his disclosure to IO of Mizoram Police that a consignment of arms has already dispatched from Myanmar DJDJ group for DJDJ group and kept in the house at Sarongwing, Aizol. On the basis of disclosure, Mizoram Police obtained search warrant. This is your lordship. Your lordship knows section 93 of the CRPC. Under what circumstances a search warrant would be issued? Because police has all the power, my lord, under
Entering and
165
search.
to seize. And even close places they can see.
All right.
On the basis of disclosure, Mizoram police obtained a search warrant and he led to the recovery of arms and ammunition from the said place. I was also part of the said team from the search of the place led by the accused. So they had to search it in the house. And then so and so was recovered. Now, then my lord, your lordship may come to page 423. 423.
Can we see this arrest memo taking over note 251, please?
My lord,
25 exhibit P 251.
251, yes, yes.
That is the document by which his
Yes.
symbolic custody was taken in this case.
Yes.
Probably.
That, I think I referred that day, 251. 54. 54, my lord, of this compilation. 54 exhibits.
Yes.
54. I do hereby seized arms and ammunition as per seizure memo dated 37 in
This
connection with,
is of the arms and ammunition only.
yes,
What about the accused?
no. That
Which is
not
the
there.
arrest memo? Arrest
That is,
memo,
that is not there. He only.
even
he
in
has
this
arrest-
case,
My lord.
even in 1/9, the arrest memo of Panlal Channa is not available.
No, the statement is not there.
Arrest memo.
No, arrest memo is not there. Oh, not exhibited, subject to correction by lord.
No,
will say,
accordingly, I moved an application to take custody of Vantia.
yes.
So that application is also not exhibited.
Not on record. We applied, in fact, I will show my lord, there is an order by the court, but it has not been produced. It fizzled out at that stage.
So for all practical purposes, there is no arrest memo on record
No.
of this accused.
My lord. And my lord, 251, one thing is very clear, if your lordship will see.
Mm.
I do hereby receive the seized arms and ammunition as per seizure memo dated 37 in connection with NIA 109, where it is. It's not there. So it seems it was seized in.
NIA 10, NIA.
It's not there.
No, you can read it that way also. I receive it in connection with so and so.
Maybe.
Is capable of the other
Then,
interpretation.
then
also.
my lord, then my lord, and then my lordship will see the next paragraph at 251 only.
Yeah.
As per order passed by judicial magistrate, IGOL 31/7, I've not seen this order. I do hereby hand over the seized articles as per seizure memo to SP CID Mizoram for safe custody.
Mm.
So, well, he has to seize, then only he can take control and give.
Mm.
But there is nothing to discover that way. It is seized on 30th and 31st he is arresting Vanlal Channa.
Yes. Carry on, please.
No, my lord, I have just referred the statement of PW 56.
56.
Karnial, he is inspector of NIA. Now, my lord, if your lordship will come to page 422.
Mm.
422. Cross-examination by Niranjan Hojai.
Probably this exhibit 254 is the petition whereby the accused was handed over in this case.
Well,
254, have you filed it, sir?
it will be there in the.
254 is not there in your,
No, my
this
lord,
set of documents.
It is, it's not there because, as I said, subject to correction, I have not seen.
Because you, if you read 422 top page,
Yes,
exhibit 254 is my petition before CJM Aizol for
Yes.
issue of order dated This is 31-7 and brought them to Guwahati and
This is certified copy, perhaps, I don't know. I will just read. it,
let's
my lord.
verify what is this.
Yes. Prayer for issue of certified copy.
No, order date, issue of order dated so and so. Okay. So only for certified copy of the order.
Yes, my lord. Certified copy of the order dated 31-7 in Isle PS 2238, which I placed, exhibit 42.
Okay, yes. Carry on, sir, please.
Now, my lord will kindly come to page 422,
Yes.
the last paragraph. The arms were recovered, my lord got it.
Mhm.
The arms were recovered from a place, Sarangwang. Now I remember that the house from where the arms were recovered and seized was from lady named Namhui.
Hmm.
He also says it is from a house and then Namhui is not before, was not produced.
The memo itself speaks.
Yes, my lord. Then my lord will come to the next page, 423.
Yes.
My lord, 13 line
Hmm.
from the bottom,
In the passport from bottom.
my lord,
Hmm.
it is correct to say that the disclosure memo of Vanlal Chana dated 37/2009, that is exhibit 43, was prepared by Mizoram police officer in connection with Aizawl case number so and so. Now, he is not saying CID. He should have said CID because he knows
Yes.
it is not by Mizoram, not by the IO.
Hmm.
Then at page again, my lord,
You are missing few lines here.
my lord, I
Continue reading.
yes. It is not a fact that disclosure memo was not disclosed, not disclosure memo of accused Vanlal Chana, and it was signed by some other person. It is not a fact. Whatever I have stated by in chief regarding consignment of arms and ammunition supplied to DSTJ by accused Vanlal Chana doesn't tally with the facts of disclosure memo. The seizure list doesn't contain any signature of the accused Vanlal Chana.
Caesar list is exhibit P.
Exhibit 250.
It does not contain the signature of.
No,
the accused.
that your lordship, my lord chief justice said the other day. Your lordship pointed that his signature is not there. I do not remember whether the signature of the accused was taken on the seal pack of arms.
This cross-examination was probably in reference to the context that there are two Vanlals. So this cross-examination is in my lord. Now you may continue.
Now, my lord, the top portion at 423, where your
Yes.
lordship has read one line.
Hmm.
The address of the accused persons appeared in the passport application form received from RPO Guwahati as Vanlal Chana, son of so-and-so, mother name so-and-so, resident of so-and-so. In the annexed document of the application.
There are no aliases.
No alias. Now, my lord, just to recap, if your lordship permit me, I will show 150, my lord, Mukesh Singh. He is in
PW 150.
150, my lord. It is there in your lordship, sir.
Yes.
And at page 236, my lord. At page 236,
Of relevant evidences.
my lord.
Yes.
236, and the relevant will be, my lord, at page 785. At page 264, my lord.
Hmm.
If your lordship will remember, I said that the weapons recovered were not sent to ballistic experts to find out whether it is in serviceable condition or it's an obsolete weapon they have collected from some armory.
Hmm.
So page 264, I'm reading 3 lines from the top. I have not got arms examined by forensic expert or the armorer of Mizoram police which were recovered in Mizoram. Exhibit 43 is prepared by Mizoram police and the officer recording the disclosure has been examined as it should have been PW 14, wrongly mentioned. So, my lord, whether these are serviceable weapons? Because one thing, my lord, it's in common knowledge that there was insurgency in Mizoram. And the top commander, Mr. Lal Denga, he surrendered. That time, a lot of arms were there. And we don't know whether this is part of that arms kept in armory. It has been just kept.
Just an off the cuff remark. What is this fascination with Lal in this area?
But that is there, Laltan Puya, your lordship has seen.
So many
Yes.
names
Yes,
starting with Lal.
yes.
Any particular?
No,
reason?
I have no idea. So far as the names are concerned, your lordship will be surprised to hear what names are given in Meghalaya. I hope they'll not mind. I'll say, my wife, she studied in my lord Loreto Convent here in Shillong, and she used to say that there are first gear Lindo, second gear Lindo, third gear Lindo, and then stop. All kind of names are there, Bright Moon, all kind of names are there. One, Kushwant Singh, my lord, wrote about the names.
Thank you.
That, let us not go there. Now, my lord, I'll refer, my lord, to exhibit 250.
Exhibit?
250,
Yes.
this is made, no, we have made it, it is in the compilation. Page number 51, my lord.
51.
I've shown it to your lordship, and in fact, my lord Chief Justice only pointed out that there is no case number. Yeah. At page 51 of my lord's, the compilation,
Yes.
your lordship will say Aizawl, District Aizawl, PS, year 2009, FIR, GD, blank. Then your lordship will say acts and sanction, section. In pursuant of the warrant to search suspected place issued by Magistrate First Class Aizawl on 37/2009. And pursuant to this, they had gone.
So not in pursuance of exhibit P43.
No. It appears because I'll just place my lord the relevant section. Now, description of place and seizure from the residence of
This makes it clear.
Nampui.
This is in pursuance of the warrant. If it had been in pursuance of 47, this would be mentioned. That in pursuance of the information accused readers and the police. That is why it's executed.
Now, my lord, you see description and place of
Yes,
seizure from the residence of Nampui, care of Lal Roha. Lal Roha is my lord the person who owns the house, and it has come in the statement of PW
he
14.
is the witness.
He's a witness, and he's the owner of the house, and his tenant is Lady Nampuya. In his house, these weapons were kept.
Hmm.
And that's how Lal Roha has not been produced. We don't know, maybe everything is, there's a connivance to implicate all these and to bring home the charges. Maybe, as I told you, my lord, one of the first cases of NIA after its
Significant fact is that this document doesn't refer to the statement exhibit P43.
nothing is, not
That
even
is
a
what-
whisper,
Neither that, nor the FIR number.
my lord. And your lordship will kindly go to page, next page.
The defense would perhaps argue that the seizure was made first and then the statement 43 was. Done.
That's a finding. And PW 14 said also that I recorded after. My lord, we'll kindly come to page 53.
Hmm.
This is used in place of seizure,
Hmm.
recovery memo. On the same, my lord, 250. Now, my lord, first we'll see on the right-hand column, signature of the investigating officer.
Hmm.
He is one HL Thangjuala.
Yes.
He is additional superintendent of police CID Mizoram.
Not
What-
examined.
He is nobody. Which case he was investigating? There is no case number. Admittedly, Aizawl PS case 438, in which they say it was recovered 238. He is not an IO of that.
One more argument which may come forward is that the weapons which have been produced here
My lord,
have no connection with 238
my lord,
because this seizure memo doesn't say
doesn't say.
that they are under 238.
No,
The seizure officer is not there.
No.
Only Kamrial is there.
no,
Karmial. Karmial is there.
Karmial, your lordship, I don't know in what capacity he was there, but he has signed, he could have signed later. After all, the witnesses have not been produced. Otherwise, they could have cross-examined when it was prepared.
Very well.
It may be a prepared document. Your lordship will see the independent witness, Lal Roha, and Another,
Both have not been examined.
they have not been examined.
Very well. Yes.
Now I'll place, my lord, section 93, because your lordship has seen, there is a statement that after the after the disclosure, they went and obtained the search warrant. I have read it in Karnial's statement. Now I'll show, my lord, CRPC, section 93, your lordship.
Yes.
Several times.
Yes. Yes, please read.
When search warrant may be issued. 93 is short. When any court has reason to believe that a person to whom a summon or order under section 91 or a requisition under subsection 1 of section 92 has been or might be addressed, will not and would not produce the document or thing as required by such summon or requisition. So this is, my lord, something for which a case has to be made out. And magistrate has to satisfy, then only search warrants are issued. In this case, my lord, they have said there is a disclosure statement and we have recovered it. 165, if my lord will kindly come to. Section 165,
Yes.
search by a police officer. Whenever an officer in charge of a police station or a police officer making an investigation has a reasonable ground for believing that anything necessary for the purpose of an investigation into any offense which he is authorized to investigate may be found in any place within the limits of the police station of which he is in charge or to which he is attached. And such thing cannot, in his opinion, be otherwise obtained without undue delay. Such officer may, after recording in writing the grounds of his belief and specifying in such writing, so far as possible, the thing for which search is to be made, search or cause search to be made for such thing in any place within the limit of such police station. And then 4 is relevant, power to seizure will apply. He will search and he will seize. So there would not have been any necessity or requirement to obtain. And in fact, in the process of making out a case where there exists none, they have.
Is that search warrant available on record?
Yes, that's how we have exhibit no, search
Exhibit?
warrant, I'm sorry, search warrant I have asked, no, it is not there.
Search warrant or the order of the magistrate?
No,
No.
I have searched.
This is in context to the fact
My lord.
that when we read this, the last, what you were reading, it says that the search warrant was procured as a consequence of the information provided
Yes,
by the accused.
Yes, yes, madam.
So then the warrant by itself would become relevant.
Yes, yes, madam.
All right, carry on.
Now, my lord. Then I will come now straight to the finding of the learned trial court.
Regarding one lal.
Madam,
Regarding one lal.
regarding my lord, regarding this point, recovery.
Yes, let's see.
My lord will kindly judgment. My lord, paragraph 201, internal page 135. Your lordship may take up appeal memo, it's on the top.
201.
201. This is at page 2010, internal page 135, my lord's copy. Paragraph 201, I'm
There is
placing.
one more witness he is referring to, that is PW 63. Probably we did not read that statement.
63, I can place my statement. 63, he is
You
a,
read from the
he
judgment.
is a DIG from Mizoram
Mhm.
Police, DSP, my lord, DY.
DYSP, that person who has signed No, that is
No.
additional SP.
Who is additional SP?
Mhm, mhm.
So may I place 201?
Yes, carry on. No, no, you please, carry on, start please.
PW 14,
Yes.
Nelson Koya Solo reports that he was inspector of police CID special branch Mizoram. In 2009, a NIA team came to Aizawl and they were looking for armed smuggler whose identity came to be known as Vanichem Vantia Vanchana, son of so-and-so, Sarang Wing Aizawl.
Mhm.
Then they arrested Vanlal Chana on 37/2009.
Oh.
Now, on 31, my lord, after 4 days remand, he was placed before the, according to the exhibit 42. Now here, the finding is, then they arrested Vanlal Chana on 37/2009 around 3:30 AM and taken Aizawl for interrogation. During interrogation, he made disclosure about weapons which you kept in the house located at surrounding.
Oh.
And on search, they recovered 8 number of M16 rifles and 1 9mm Beretta pistol.
Where does the trial court get this fact from?
I-
Then they arrested Vanlal Chana at around 3:30 AM.
I have not.
That was not there in
I have-
PW 14.
That was not there. I have also not got.
No, this is a
Because
misreading.
2-3
because
things I
He is
wanted.
referring to the statement of PW 14. Who
Yes.
doesn't say so?
No, he doesn't say.
Okay.
He says so one Vanlal Chana, he says was roaming around, the one
Roaming
whose
around.
statement he recorded.
No, assuming that it was an arrest, but Vanlal Chem.
No,
So he doesn't say the time of arrest.
he
He
doesn't.
says that he was already in custody.
Yes.
PW 14, he says.
Yeah, he says on 26. He says on 26/7,
26,
the first page.
Yes.
Hmm? Oh, he say 3:30 AM, but he says at 27/2009.
27. That's what I'm saying.
27
This is
at page 29.
a- this is sort of misreading from the statement.
My lord. So there's a lot of misreading. my lord.
Taken to Aizawl for interrogation.
Yes.
He doesn't say so.
And my lord, he was produced on 26 or 27, he was remanded. IO says 3 days, magistrate's order says after
4
4
days.
days. 8 number of M16 rifle, 1
You need
9.
to, you can skip that.
Yes, my lord.
Read the relevant things.
Then they also recovered passport. Then my lord, it is elicited in the cross examination.
Yes, 43 was prepared
Yes,
by him after the recovery of weapons at the
yes,
base.
yes, my lord. After the recovery of weapon, seizure list was prepared. It is also elicited when they went to recover material exhibit, they found one Lal Chana in village Lungmoa. This I have already stated. my lord. He was at large at that point of time when they met Vanlal Chana. He is nowhere connected with any case. It is also elicited that exhibit 43 was prepared by him after recovery of weapons at the behest of NIA. It also elicited that he believed the contents of exhibit 43 to be true. Then my lord will come to paragraph 204 at page 2015. Your lordship, it will be 140. 140. Thus, what is transpired from the above discussion is
This is my judgment.
that apparently the accused was not in police custody of NIA case number 1 of 2009 on 37.
Hmm.
On which date he made disclosure statement, exhibit 43. And consequently, the arms and ammunition were recovered. But he was in the custody of ILPS case number 238 of 2009 since his arrest on 26/7/2009. Now he says 26/7. It was on 31/7, the accused during interrogation revealed that the recovered arms have no connection with Mizoram police case number so-and-so as they were meant for DHD group. The Aizawl PS case number then filed a disclosure report on so-and-so before the concerned court and the same was allowed.
Hmm.
Now, your lordship will kindly see the only evidence on record, according to my lord, of course, subject to correction from what he says, but I have not seen anywhere that it is mentioned that, my lord, there is an evidence that these weapons were meant for DHDJ, except that during police
Interrogation.
interrogation he has said. And in fact, my lord, I can take a straightway to that portion where learned trial court says, yeah, it is true, there is no admissible evidence. But then again, he says, but because of this. There are 2-3 paragraphs where clinching evidence, he said there is no proof, but fact remains so and so. He says that. Now, I will take your lordships to paragraph 208. 208
Yes.
at page, I'll just give you at page 142, my lord,
Yes.
142. I'll start from 207 only. Having understood the object and scope of section 27 of the Relevant
Refer
Act-
to 27, sir. There is no point. As a matter of fact,
Oh.
we do respect to you also.
My lord.
You wasted 1 hour in 27.
Alright.
The straightforward argument is that there was no recovery in pursuance of 43. So why 27 is to be discussed?
Correct. I said
It's
right.
just sheer wastage of time.
Yes,
There's a finding.
Yes.
208,
yes.
then what is the need of discussing to 27? Read para 208.
Although the disclosure statement exhibit 43 is inadmissible, again, he says that I can't help it everywhere your lordship will find the repetition. That's how anyway, no
Mr.
issue.
Mishra, sorry, I am little impatient, but the fact is that when the fundamental document is the Caesar memo,
Yes,
wherein there is no reference of 27
yes, that.
and there is no signature of the accused.
In fact. if
Why
you
do
look-
we need to discuss
Yes,
27?
Right from
Unless,
first-
unless
from first
you have
glance.
made it a mind to educate
no, not at
us,
all.
we are happy for that.
No, I'm not here to show
But
my.
that is consuming
thing.
unnecessary
No,
time.
Not at all. I'm here, my lord, because of the whom I'm representing. I have no other interest. 208, although disclosure memo of.
And yes, to the benefit of the young people
inadmissible
and
here in this case,
yes.
being not recorded prior to recovery of the arms and ammunition. Now, this is what is important, yet, if your lordship has.
Yes, yes.
Yet the fact remains that arms and ammunitions were recovered and seized on being led and shown by accused.
So, sir, I'll let you know. I'll just share my experience. If I had been arguing the case, I would just read these 3 lines and refer to the Caesar memo. That's all. Nothing more is required.
My lord, I'm still to learn.
Everyone has
My lord.
is required to learn, sir. Keep on learning.
Yes, we do it.
But
We do it.
it is a fact that beyond this, there is hardly anything to be referred.
My lord. All right, the last 208, just last 3 lines is that
Yes, but this disclosure statement.
statement, post-crime conduct of the accused.
Mm.
Accused under the second paragraph of section 8 of the
The
evidence.
next argument will be 25, 26 of the evidence side.
Yes. Now, he refers to my lord Mahibur Rahman's case. Mahibur Rahman case is on a different footing altogether. I have placed it. If your lordship desires, I can place it or I can.
Here you are, please.
But here in this case, my lord, which the learned trial court has relied,
Mm.
there, my lord, a person had died. Now, the person, the accused said, I will take you and discover his
Body.
body. It was in presence of the magistrate, it was exhumed, the body was
Exhumed.
exhumed. So that, and there was no, the 227 statement was said that it was recorded after the recovery.
Mm.
So in that context, my lord, it is said that it was in exclusive knowledge because he
Pointed it out.
pointed it out and it was dug out.
He dug it out.
It was not. Now, the another finding of the ultimate finding of the London trial court is at 466, page 466.
There are
287,
466.
287,
287.
287. Four six six.
Yes.
It is to be mentioned here that except the version of the accused that the arms were meant for DSDJ, there is no direct evidence to link the recovered arms with DSDJ. My lord got it.
You're reading at
Page 287.
page 287.
Correct. paragraph 466. This is the ultimate finding on this point.
Let's, yes,
It is to be mentioned here that except the version of the accused that the arms were meant for DHDJ, there is no direct evidence to link the recovered arms with DSDJ. And being made before the police, his statement cannot be taken into account.
and the
But there is
conversion of
evidence-
currency.
But there is evidence to show that the accused Banlal Chana received US dollar from accused Malsa Kimi, who converted the Indian currency at the instance of PW 29, George Lamthang, after receiving the same from accused Khojinder Hojai at Calcutta. What he did with the US dollar was in exclusive knowledge, and as such, he is bound to explain. But in his examination 313, he failed to give any plausible explanation for the same. This being the position, this court is entitled to draw inference under 106 of the Evidence Act. Evidence Act, that with the said US dollar, he purchased the seized arms. Your Lordship will kindly stop me if I am repeating. I'll immediately stand corrected. But, my Lord, I'll submit before Your Lordship that I have been repeatedly arguing that there is no evidence
To show
that
that
accused 9 received money from accused 1. Right from beginning, I can say, starting from Guwahati, but I'll not repeat. There is no evidence at all, even Banlal Chana, my Lord, and there is no evidence that A9 has given dollar to accused.
whether any amount was converted into dollars,
Nothing is
there is
there.
no physical evidence for that.
No, and my
Except
Lord,
for the confessional statement or George Lamthang.
George
An
Lanthan,
inference of George Lamthang.
but he also doesn't say that A9 has given dollar to A8. Even he says, I don't know. That I have shown required, I can show it again. And of course, no dollar was seized. Now, my Lord, the trial court relied on a decision, my Lord, of Muhammad Omar's, that is 2000 volume 8,
106.
106. That is last scene, my Lord.
What is the fact exclusively knowledge?
Yes. Now, here, my Lord, there was a person who was taken from his house and he was beaten. He ran away, he took shelter. Again, from there, he was taken and he was being beaten and he was taken away. After that, his
He was
whereabouts,
not seen alive.
no, he was not seen alive.
So 106 in
Yes.
that situation would
In
be
that, yes,
definitely on the.
that last scene. So I need not refer then that. Now, my Lord, as I have submitted, my Lord, the cost of repetition that there has been no evidence have been created. Now, here in this case, exhibit 118 was created, by which a declaration was given by A8 to this effect. I'll show, my Lord. At page 118, exhibit, you are not listening.
Page 42,
Page 42.
exhibit company.
Exhibit compiled page 42. Where is that? Page 42.
Yes. Disclosure memo.
Yes,
Yes.
this is disclosure memo. In the above mentioned case, the accused Banlal Chama Vantia so and so, in presence of Shri Navajit Buragohai, Assistant Inspector of Excise Department, Kamrup Metro, to the assistant IO of the case, Shri Santosh Kumar, Inspector of Police NIA, New Delhi. The disclosure statement made by the accused is recorded in Mizo language. Then the translation is below that, my lord. This disclosure made in Mizo language was translated to English by Sri Lal Sangha, Sub-Inspector of Police CID SV Mizoram, as under. I know a lady named Swami. She stays in Aizawl. She, along with another person, Thanga, used to convert Indian rupees to US dollar for me to be supplied to DHD group. 3 times. I took their help for this work. She used to. No, my lord, in my humble submission, this will be hit by section 26 of the Evidence Act. I need not say anything else. Although, my lord,
Has the trial court relied upon this?
yes.
Please read the finding.
Right. Lord, actually, I have that way prepared if I have to skip. then
You do it
will-
in your sequence, in the
because- so
sequence
then
you have
I'm
prepared.
taking your lordship's time.
You referred to 118, that is why the question was,
Right.
that whether the
Yeah,
document
yeah,
is
I'll-
relied
I'll-
upon or not.
Yes, my lord, I will definitely, my lord, place before your lordship.
Very well, you
That's
do it
what-
when, as
My-
per your convenience.
My lord. Now, my lord, one Lal Sangha who said,
This is an exhibit or not? This is an exhibit.
this is an exhibit, my lord,
Exhibit 118, 188,
118.
118.
118, page 42 of your lordship's compilation, my lord.
Market is an exhibit system. What is the process here?
Now, if your lordship will see, Lal Sangha, one Lal Sangha who translated is a witness. Now, he is a witness in 2-3 places. Oh, his statement is, my lord, recorded as PW 57. Just 2 lines of statement, if your lordship will permit me to make with it. Evidence. Oh, then your lordship has to take paper book volume 2. This was the paper book volume 2.
Exhibit.
A document number 2 to 5.
You may read it first.
Well, no, just 3 lines, but
Yes.
this document number is mentioned,
PW,
PW 57. But my lord, he is examined and he says about only one document that I'll have to find out.
you read please.
On 3/7/2009, I was posted at CID SB headquarters, Aizawl, Mizoram government as sub-inspector.
37,
Yes, 37.
30th,
30.
30th, right.
When the Caesar list document 225 1/2, this I have to find out, was shown to the witness, he only identified his signature as a witness.
That may be the list which was prepared when the weapons were handed over to the NIU.
I'll correct.
Most
I'm sorry,
likely it is that
yes,
list.
Yes. I do not know who has drawn this document, but this document contains my signature as a witness. This is what he says. It is on an exhibit to paper book 2. At page 4 to 6, my lord, his statement is.
Mm. Very well. He doesn't say about the translation.
He doesn't say.
Otherwise
He
also-
doesn't say.
Hmm.
I don't know if he has again
Record.
examined, but I don't know. This is what papers are.
Hmm.
Then. Now, another thing, my lord, another exhibit, which I will place before your lordship, that also was created for the purpose of evidence, as there is no evidence, I'm repeating it. So 3 evidence, exhibit 241, 242, and 243. Exhibit paper book 5, you can give. 241. Exhibit 241. Exhibit paper book. Page 48.
You have it in this set?
Yes, in that page, page 48.
Yes. 48.
Yes.
Mm.
My
Yes.
lord, Page 40. Page 48,
Exhibit-
I will first place 240. 241, my lord.
241.
In connection with the investigation of the subject cited, Shri Vanlal Chana alias so and so is in police custody of NIA.
Hmm.
This is 8/8/2009. During his examination, he expressed that he could identify some other suspects accused of this case if shown to him. It has been decided to show him photographs of Niranjan Hodai and Jewel Garlosa mixed with other lookalike photographs and his identity, the photographs if he can. For this purpose, the services of above mentioned witnesses have been requisitioned. And services of Sri Lal Sangha, SI Mizo has been requested to the, what is it? To the
Services of Lal Sangha, SI Mizoram has been requested to be the independent.
to be the
Interpreter.
interpreter. Also decided to take some accused from the
Lockup.
up to the above, very difficult to mention,
Neutral place.
Accordingly, yes, accordingly, along with accused and team, reached above mentioned address, accused so-and-so was shown total 11 photographs. After showing the photograph, the accused identified.
Why do they go to this house? What is special about this house?
Nothing clear. Maybe they thought that they will leave the police station, it will become more authentic, except that I cannot say with anything. Now, this is not even in presence of an executive or executive magistrate. No. This is, there are four witnesses. CP Fukan, he's executive magistrate, then Nawajid Buragohain, Salsang, and DSP CBI. Now, this will be hit by 26, my lord. Because 25 and 26, this will be hit by, because this is.
Even if we assume that this is relevant, then what is conveys is that he knows Fojendra Uzai and Mohit Uzai. What of that?
That your lordship has said is not a substantive evidence. Your lordship-
How it is incriminating?
Yes. Then your lordship will see 242, the photograph, they say that case number so-and-so, these are the photographs, 242, photograph is not there, and 243. Page 49.
Yes.
Then, my lord, this I can place, my lord, straightway where it has been relied. My lord may come to paragraph 419. 419 at page 264 of the judgment. The relevance is at 2140. The first page I will refer, my lord, when I argue accused number 1 page. Your lordship will see at page 265. 265.
Yes.
My lord, 8 lines from the top. It is however true. My lord got it. It is however true that there is no direct evidence to show that from accused Banlal Chana where the dollars have gone. But it stands proof that he is an armed smuggler and his instance huge quantity of arms and ammunition were recovered. Though there is absence of legal evidence to establish that he procured armed and communication equipment and supplied the same to DSD, yet he is acquainted with Niranjan Hojai and Yuval Rotha and identified their photographs in a photo identity in presence of independent witnesses.
Yes, and in any event, that is a statement made by a police, accused in police custody. What he was doing, spoken. Pressure of the case. Is the case of the judgment recent 17. Like that. Things are watered down. Any? Yes.
No, my lord. It is alleged that they recovered 10 lakhs from accused number 9. Why I'm saying I'm not appearing for accused number 9, but there is I'd say the octopus led 120B. That's how I have to refer to it. Your lordship, they say that they seized 10 lakhs from A9.
Malsakini, yes.
And that they are, my lord, relying again on another declaration. That is exhibit 256, 257.
How this declaration was dealt with?
When she was arrested.
No.
My lord.
This declaration made by Vanlal.
Because, no, not one.
What the finding you read?
A9.
You read, just now you read the earlier one,
Yes, yes. my lord.
254, we suppose.
My lord, I placed that, that 118.
Para.
No, exhibit 118, I placed. That is the declaration.
That's what we are asking, sir. How trial court dealt with it? It has been held to be admissible.
My lord, I will place it 118. I'm not getting, I'll place it somewhere. It is missed in the note. I'll place. But so far as my lord, this finding is concerned, my lord, that there is
Small
no.
query, small query. You must have argued before the trial court that this is hit by 26.
My lord, must have been argued as
So
well.
where is the finding on this document? You don't.
118.
Yeah,
That declaration, that
Declaration is 118.
one.
Where is the finding of the trial court on this
My
declaration?
lord, I'll,
Once you refer to the document,
yes, yes,
if it is convenient to refer to that, please point it out.
yes, yes, my lord. 1184 assessment.
चलिए नहीं ध्यान है तो आप कल you
I'll
tell- let us know
definitely,
tomorrow.
I'll definitely.
Tomorrow.
My lord, it's somewhere it makes, but my lord, at this point of time, what I would say, my lord, is I'll place a very interesting question that was put to accuse number 8, Valnal Chand.
Mhm,
Because your lordship has seen, he says that he has to explain where the dollar has gone.
mhm.
He has not explained, therefore it is proved. So here also, he made a statement before the police that he has got this weapon for DSPJ, but there is no legal evidence, but yet he knows Niranjan and Jewel. So I don't know how it is relevant. So this question was put. And your lordship will kindly have paper book number 5. Paper book
313.
Number 5.
You are referring to 313 statement.
313 statement. Exhibit paper book 257. You are not. My lord, page 56, that exhibit 257 is there.
Of the relevant exhibit.
1169.
You are referring to documents or what?
No, this is examination, my lord, by the 313 examination, my lord.
Page,
Page 1169. Sorry, my lord, I'm sorry. Question number 67 is at page 1195. 1195.
yes.
Question number 67, I'm placing your lordship got my lord 1195.
Mm.
PW 150 also deposed that as per direction of Niranjan Hojai, so and so directed the then CM Dipolal Hojai to resign and to make way for Mohit Hojai. And accordingly, Dipolal Hojai resigned and Mohit Hojai took over charge as CEM. And in the first week of January 2009, he held meeting with R.H. Khan, Karuna Saikia, Jayanto Ghosh and others and started defalcating funds of development and sent funds to Jayanto Ghosh and Fajinder Hojai to DSPJ. And further handed over the cash to Fajinder Hojai, who handed over the same to George Lamthang and Malsa Kimi.
He is the IO. 150 is the IO.
He is, my lord, accused number 8.
150 is the IO.
150 is the IO, Mukesh Singh, CIO.
Yes.
Fajinder Hojai to DSG and further handed over the cash to Fajinder Hojai, who handed over the same to George Lanthang and Malsa Kimi, who converted the same to dollar and handed over to you. The answer is lordship has seen. It is completely false, baseless, and the question put to me is not borne out by material on record.
Yes, please.
Now, my lord, I'll come to.
Sorry. Yes.
Now I will come, my lord, to the seizure of 10 lakhs. I'll just say what I want to show. There is a declaration which has been exhibited as 257. There, Malsa Kimi is supposed to have said that I have kept 10 lakhs after her arrest in my house and I will need to discover. And it was discovered by PW 59.
Yes.
Now, PW 59 says there is no seizure list.
Okay.
There is no seizure list. Only for that purpose I wanted to show.
There is no Caesar list at all.
No, this I will show. My lord, page, your lordship may have 59. No, page 50, PW 59, my lord. Your lord, in your lordship's compilation, it will be 157. 157.
One 157 of this
PW 59.
compilation or
Yeah, no, in
Compilation of relevant evidence.
your lordship's that compilation. So many compilation. Relevant witnesses. Your Lordship, page
59 you are referring to?
157.
157. Yes.
157, the relevant will be at 159.
Mm.
Cross-examination by accused Malsa Kimi.
Yes.
I cannot say exact date of arrest of the accused without going through exhibit, the record. Exhibit 257, the disclosure statement is written by me. Apart from police officer, there were no independent witnesses present at the time of recording the disclosure statement. Exhibit 257, 258. There is no separate seizure list as regards 10 lakhs from hotel.
Mm.
It is not a fact that exhibit 257 and 258 were not recorded in recording. So without seizure list, it has
There
been
was no seizure at all.
no seizure.
Information
But there
not
is,
followed by any discovery.
yeah, but my lord, there is an order when we have checked up, my lord, the record of the lower court. The permission was sought to deposit something in treasury. Whether it was deposited, it was not deposited, those are not there. They're not there. Now, then, my lord, it is alleged that they have seized 5 lakhs from the approver when he was, because he was made approver after 5 years.
Mm.
And his application also I'll place before Lord.
Mm.
So he made a statement, but there is no seizure list. 5 lakhs. And one thing which I'll show to your lordship, this disclosure statement was made initially after the arrest. And there he says that the money is my ancestral money, or I'll just place, it is this. I want Peter. The, my lord, exhibit 78, we'll give. My lord.
Page 31,
Page 31.
exhibit.
Yes.
My lord,
Yes.
my lord, at page 31, my lord, we come to the last paragraph, I have to further disclose that I used to hand over Indian currency as well as dollars to Malsa Kimi for her
For the transaction.
transactions,
her.
for the transactions, well known to her. I would like to disclose that a sum of rupees 5 lakhs has been kept at so and so place. The said amount is my ancestral heritage property. Subsequently, he says this is the amount given by Malsa Kimi, accused number 9. Now, what is left is, my lord, the finding on the terrorist act in the judgment. And these evidences I have already placed, few witnesses I have to place. And thereafter, my lord, I will place, my lord, finding on the conspiracy. And then section 17. That will bring an end. Only these 3 points are left. And I will surely, my lord, find out 118 and your lordship. So I should have it written somewhere, but I'm not getting it. Not getting it. Hmm?
Yes.
Then I'll place, my lord, the finding on the terrorist act. Para 456 at page 283.
There are 455 is a definition,
My lord,
and then 456.
456, to
Yes.
establish terrorist act, the prosecution side has relied on PW 20, Long Sing Langthasa, PW 23 Kulender Dwalagopu, PW 24 Amitabh Sinha, then PW 46 Narang Doku, PW 126 Drupalal Hodai, and 129 Dilip Nunitha. Out of these, except two witnesses, PW 24 and PW 46,
Yes.
I have referred all, while my lord, the first point I was arguing that
Resignation.
Deepolal was forced to resign. And what I had shown, my lord, is their statement made under 161 was placed. The same thing has been done here. If your lordship desires, I can give the paragraphs where their statements have been in the judgment where it is discussed.
Yes.
My lord, or I can, my lord, make a list,
Yes.
and then give it to your lordship.
As per your convenience.
So whatever your lordship says.
We are fine. You argue it as your ways. PW 24
PW
is the IO, one of the
No,
investigating
no,
officers.
He is not, my lord, he has nothing to do with investigation. He was additional SP, Haplong. He was posted in headquarters.
So he gives out a general idea about
Then
what is the thing.
That's all. And whatever he says is, my lord, that recovery of arms post mass surrender. So
So-
those things he says, that I have not placed, I'll place that. And then I will place 46,
Mm.
who says that my knowledge about these terrorist acts are based on media report.
Mm.
And others 20, 23, 126, and 129, I have already played. Well, I'll give a short synopsis of what I have submitted before.
Very
your
well,
lordship.
very well.
I'll first place, my lord, PW 46.
Hmm.
PW 46 Asin Nai. Nairang Daula Goku. I have, this also I have placed, my lord, where I had shown that he is an ex-cadre of DHD. He has nothing to do with DHDJ,
Mm.
if your lordship remember.
Yes, yes.
No. Okay. So, my lord, this is volume 2, paper book 378. I'm sorry, it is not in your lordship's
It is not
compilation
there?
of witnesses.
Volume 2.
Volume 2, my lord.
Volume 2, page.
Page 378. my lord.
Yes. Please.
I joined DHDJ in 1995.
Oh.
This is a militant organization led by Joel Garlosa, who was the chairman of the group. I remained with the organization from 1995 to 2003. This
Hmm.
militant organization was operating in Karbi Anglong and in Hills, now Dima Hasao. The arms and ammunition required for the operation of the organization were purchased locally. So all this is talking of DHD, not DHDJ.
Between the period 295 to 2003.
My lord. Then next page, if my lord will see, on January, second para, on January 2003, ceasefire was declared between the militant and the government, and around 300 cadres, including me, on signing ceasefire agreement, we shifted to the designated camp. In October 2003, the organization was separated, and so-and-so went and formed another militant organization in the name of DHDJ.
Yeah.
This is
So-
what, and then he was shot by one Daku
Daku
Singh.
Singh.
Those must be from other cases, must have been registered.
Mhm.
We have no idea. Now, discussion of this witness is, your lordship will find in 3 paragraphs.
Mm.
439 at page 275. 2150. 2150.
439.
Yes.
27.
27.
The evidence of PW6, Nairang Dolagopu reveals that he joined DHD in 1995. DHD is a militant organization led by so-and-so, so-and-so. All this, what he has stated about DHD, my lord.
Hmm.
440 is also same. And then your lordship will come to page 283, 458. 458. Not only the, at page, I'm reading at page 283, the last para. Not only the evidence of PW 24, but also the evidence of PW 46, Naring Dolagopu also revealed that he joined DHDJ as militant organization led by Joel Garlosa, who was chairman of the group in 1995. The arms and ammunition required for operation. So again, my lord, same thing is same is a repetition only. And then he was attacked by Daku Singh. Same thing.
Oh.
So these are the finding about 46. And then, my lord, Amitabh Sinha, he was additional SP. He is PW 24. His statement is also not there, my lord, in your lordship compilation.
PW 24.
24, my lord. Volume 1, page 81. Volume 1, page 81.
Yes. Volume 1.
I'll take this.
Volume 1. Yes, this is it. Page 81. Yes.
Good. I joined in March 2009 as additional SP headquarters at NC Hill. I continued up to December 2010. NC Hills is presently known as Dima Hasao. At NC Hills, I was responsible for maintenance of law and order and crime detection area. Immediately after my joining, there was a spurt in violence because of DHPJ. There were Naga and Dimasa ethnic clashes. DHPJ has stopped the train service flying from Lamding to Badarpur, thus virtually stopping the food grains not only to Barak Valley, but also to states like Mizoram, Tripura, and Manipur. DHT would resort to firing on the moving trains from hills on both sides of more than 120-kilometer railway track. This was the situation when I joined. Because of the counter-insurgency operation, lots of additional forces were deployed, things gradually improved, finally leading to laying down arms by DSPJ. But there was always a feeling that an apprehension and some intelligence input, as well as that all the arms and ammunition of DSBJ were not handed over at the time of laying down arms. On 8/7/2010, we received specific information that a consignment of arms and ammunition were kept hidden in the jungle. After verifying this information that there was some authentic input, we received, I on the instruction of the SP Dima Hasao conducted a search of Disa clan area. I was accompanied by O.C. Haftom. A large number of us thereafter on search we found some gunny bags, some behind rocks, some concealed with earth and opening of sacks we found large number of sophisticated weapons, including AK-47, M16. So we found that these were indeed highly sophisticated factory-made weapons. There was no question of any witness, and there was no habitation in the area. It was dense jungle, but in presence of police witnesses, the arms were seized.
This is in relation to a different Caesar.
Different
After
FIR
this
number is
FIR.
there. And the, my lord, exhibits which would be relevant, if your lordship permit me, are exhibit 57, 58, 59, 60, and 61.
Of what these
Of
recoveries are.
these, my lord, these two are the letter of NIA because they got all the FIR. And on that basis, they say that they were, the DSJ was a terrorist gang. So 57 is the first information report, my lord. Page 12 of your lordship, this compilation.
Yes.
This is, your lordship will see,
9,
FR
7, 10.
54, half long, on the left-hand side at page 1.
Yes.
Then, my lord, This is in format. Then your lordship will see this page 58 at page 14, my lord. Based on confidential information, SP so and so, and these weapons were seized. And then on the right hand side, your lordship will see received and registered Haflong case number so and so. So this is of a different case. The seizure was made. And exhibit 60, if my lord will see, 60. Exhibit 60 is a letter, my lord. Then your lordship will, from here, your lordship, I will, page 18, 18. This is how the NIA came to know about these, and they have mentioned in their charge. There is no independent investigation into all this, and these are not subject matter of trial. With due respect, I am forwarding herewith the below descriptions, duplicate copies of the Haflong PS case, which is mentioned above. And this is addressed to Superintendent NIA. Then the next one again, my lord, all these cases where
2001, 2000.
my lord,
FIRs are of 2000 and 2001.
yes, yes, 2000 and 2001. These are, yes, subject information regarding NIA case 2 of 2009. This is not of 1 also. And then, my lord, if your lordship remember, I had referred exhibit 271, 272, which contain the attacks on police personnel and which is subject matter of investigation and trial in a different place. That your lordship may just have a glance on it. My lord will kindly turn to page 59 of this compilation. This is against my lord SP Pani, he is PW 146, the investigating officer. With reference to, I'm furnished here with the following information, then list of cases, all these are there. Then your lordship will find at page, page 61 and 62, all these cases where it is registered. These are the, and your lordship will find some of them in charge number 4. I'll place charge number 4. They're not even subject matter, but it found in charge number 4.
Conduct kind of thing.
Well,
Are these persons arraigned as accused in these cases?
no, no. And my lord, your lordship will see this at page this page 61. My lord will see
The chart,
the chart.
table, yes. 2004, 2008.
Yes, and not only that, my lord, your lordship will see the first one, miscreant on 11/6 at 1:30, about 15 to 16 number of miscreant.
You must have cross-examined the witness regarding who are the accused in this case.
In these cases.
Yes,
Unfortunately, I have not seen. Unfortunately, I have not seen.
they are coming out with their so-called antecedents.
Yes,
Then the natural query would rise whether these persons are accused in these cases. or-
no, these cases are different, my lord, because,
Maybe,
Yes.
maybe irrespective.
no, they are
These
not,
are for the purpose of showing their conduct.
yes,
That is what they are trying to say.
yes.
If there are so many cases against you,
No, but
these-
it's not against me. That's what I wanted to show, my lord.
so how do we find out?
Unknown extremist. In the chart. if
That
you
was
look-
written in the, these are charge sheet submissions. Brief
No,
of
these
cases.
are list of arms and ammunition snatched by extremists with case reference, etc. Then Umrangsu PS case number, Umrangsu PS case number. The third one, your lordship will see, suddenly some unknown extremist. And I have said, well, it's in the evidence that there were so many insurgent groups operating in the area. Then 4 also, my lord, moreover, extremist groups snatched the arms. Then 5 also same thing, some extremists. Then again, my lord, no name is mentioned, and even the extremist names are also not mentioned. And because this was subject matter of investigation, so we don't know what has happened in this case. And in any case, my lord, accused number 3, Mohit Hurai has nothing to do with these, my lord. He was, because these are 2006, he became, my lord, a member of the Autonomous Council in 2007. If he was involved, he would not have been permitted to contest, my lord. He is a politician, he has been implicated. Now, my lord, few paragraphs I want to show. Page 464, paragraph 464 at page 285 of the judgment, if my lord will kindly see. 464.
Yes.
My lord, page 464, paragraph 464. If your lordship will see page, fourth line from the top, my lord, next page, 286. Though there is no direct evidence to link that the arms recovered from Visa Clean and belong to DHDJ, yet evidence of PW24 is clear that DHD has not handed over all the arms. Now, this is in my respectful submission forward. Because what PW24 says, my lord, that there was intelligence input and there was apprehension that the entire arms have not been deposited or surrendered. If your lordship, I can refer it again. If your lordship remember, I can proceed. PW24 very clearly says, my lord. Then your lordship will see the next line. On a specific information and verification of the said arms were recovered. Now it is to be seen from where DHDJ brought these arms and ammunition. In this regard, evidence of PW6 Narang Doku is material. He was called a cadre of DHDJ. Now, my lord, your lordship has seen 46. It's not DHDJ, he was DHD, joined in 1995. Now, even PW20 later on, your lordship will say on the 12th line, if I come down, PWT20 is another cadre of DHDJ. Then again say 129 is another cadre of DHDJ. Now these are perverse findings, my lord, with all the respect. These findings are not correct. Because they themselves, they have nothing to do with DHDJ. Then my lord will kindly come to the finding on conspiracy. Can I continue tomorrow? Your lordship. In my mind that 118 is moving where I have lived. And
Well, thereafter we'll continue. We'll continue. We have a green bench at 2 o'clock, but once that proceeding is over, we'll again commence this evening. That will not take more than 10 minutes.
My lord, the next case was mine. And there's some urgency, it was not possible. My lord, dismissed employee, my lord, Larned Singhal was my lord reinstated, my lord, setting aside the order of penalty. My lord, any day, my lord, subject to convenience of the court next week, my lord.
There was an adjournment slip, sir.
No, that was not filed without our consent.
Very well. You can have it in first week of June.
No, my lord, kindly in the next week, my lord.
So not possible, sir. Absolutely not.
Oh, my lord, the week is starting 15th of May, my lord.
At best, we can give you on 30th May. That is the earliest possible.
My lord, a young man of 28 years, my lord, dismissed, my lord, harsher punishment, my lord.
So we are trying our best.
And
Try to bear with us.
23rd of May, my lord.
23rd, they
Obliged, lord.